sergeants close the doors. Members remain at your desk and indicate your presence by entering your aye or no vote. Got it.
Yeah, I'll tell you as soon as Janelle is. I think that's good.
Representatives Arndt, Becker J, Becker K, Buck, Corum, Danielson, Del Grosso, Everett, Humphrey, Pedersen, Priola, Sane, Vigil, and Willett.
Where's Priola?
So is Corum. Yeah.
I know, I forgot his teacher.
You did. Polar, I got screwed all the way around.
I know, sorry. Now that one should work.
Are you serious?
I can switch it right now.
We actually haven't brought the house to order yet.
You guys have just got me on my toes.
Call the house, then I'm gonna
Apparently not for you, because you're not doing it right.
add the bills to the account.
Right, but you have to wait till the house is and then what we'll do is we'll recess to allow them to meet.
Sounds good. Does Penn need to know the calendar list?
We have it.
You got it?
We're on it, Representative Young. You're,
We're all set?
I don't know who else.
we're on it.
That's what I understand. I wish I was on it.
Representatives Arndt, Danielson, Del Grosso, Pedersen, Priola, Sane, and Vigil.
No, she doesn't.
Representatives Arndt, Del Grosso, Priola, Sane, and Vigil.
Madam Majority Leader.
Thank you, Mr. Speaker Pro Tem. I live to call the House.
Call of the House has been raised. Young, Dave, you know you got to announce the meeting and the bills that are on the agenda.
Are we planning to do that? Have we got them yet?
Yes, we're just waiting for you. Take your time.
Do something I have not done before, and that is get organized.
It's only me staring at you right now.
Well, I don't really feel self-conscious about that because
And everyone asking me, why aren't we doing anything? And I say, look
everybody's
at
looking
Young.
at you instead.
And everyone asking me, why aren't we doing anything? And I say, look at Young.
But they can't see me because I'm too short and you're right up there. So, that's the bottom line.
Not awkward at all. Okay, bye. Representative Young.
Thank you, Mr. Speaker Pro Tem. I am announcing that we are about to have an Appropriations Committee meeting here in the Well. It will start as soon as this announcement is over. And the bills that we will be hearing are House Bill 1343, Senate Bill 003, Senate Bill 3, Senate Bill 36, Senate Bill 104, Senate Bill 143, Senate Bill 155, and Senate Bill 186.
All right, the
Appropriations
House will
Committee,
be, Representative Young, go ahead.
House Appropriations Committee members, please come down to the well now. And thank you, Mr. Speaker Pro Tem.
All right, the House will be in a brief recess to allow for the Appropriations Committee to meet. House will come back to order. Coat rule is relaxed. Reports of committees of reference. House will be in a brief recess.
Finding him.
House will come back to order. Reports of committees of reference.
The Committee on Appropriations, after consideration on the merits committee concurrence following House Bill 1343, refer to the Committee of the Whole with favorable recommendation. Senate Bill 155 be postponed indefinitely. Senate Bill 3, refer to the Committee of the Whole with favorable recommendation. Senate Bill 36, amended as follows, and as so refer to the Committee of the Whole with favorable recommendation. Senate Bills 104 and 143 and 186, refer to the Committee of the Whole with favorable recommendation. He's got to print out more.
What's technically up on the next order of business? General order?
Well,
Is it just continuation of special orders?
She's going to add to it.
She's gonna add to it, so we have to wait. We can't go into special orders. She's gonna add all those bills.
Croissant.
The House will come back to order. Mr. Kohler, please read the title of Senate Bill 198.
Senate Bill 198 by Senator Holbert, also Representative Kraft Tharp, concerning the standards applicable to documents used by workers' compensation insurance carriers in Colorado in connection with requiring advisory organizations and rating organizations to file sample forms, policies, riders, letters, notices, and other documents to the Commissioner of Insurance.
Representative Kraft Tharp.
Thank you, Madam Speaker. Madam Speaker, I move for suspension of Rule 35A for the purpose of reconsideration.
The motion is for reconsideration of Senate Bill 198. And the motion before us then is for reconsideration of that third reading vote on Senate Bill 198. This requires only a majority vote because we are in the last days of session, so we don't need to suspend that rule. Is there a discussion? Please proceed, Representative Kraft Tharp.
Thank you, Madam Chair. I move for reconsideration of the House last action on House Bill 198, which was passage on third reading.
That's a proper motion.
Thank you.
Please proceed to explain.
Thank you.
Representative
So
Kraft Tharp.
if you remember, a couple days ago, we passed 198, which was the most fascinating bill of the year. This was streamlining the workers' compensation forms. This morning, I asked for a recall motion, and that was because, if you remember, there was an amendment put on the Senate. That amendment did not get put into the bill, so it was discovered before the bill made it to the governor's desk for signature. So we recalled that action. Now we're reconsidering that third reading motion. Thank you.
So the motion is consideration of Senate Bill 198. Is there any further discussion? Seeing none, Mr. Kohler, please open the machine and members proceed to vote. Representatives Kay Becker, Kagan, Navarro, Pabon, Vigil, and Young. Representatives Kagan, Navarro, Pabon, Vigil, and Young.
Representative Moreno. What about Kagan?
I haven't seen him.
He was here a minute ago.
Representatives Kagan and Navarro.
Representative Del Grosso? Do you want her excused?
Representative Kagan and Navarro excused. Close the machine with 61 ayes, 1 no, and 3 excused. Reconsideration for Senate Bill 198 is passed. Representative Kraft Tharp.
Thank you, Madam Speaker. Madam Speaker, I move for passage of Senate Bill 198 as amended.
The motion is for passage of Senate Bill 198 as amended on third reading and final passage. Is there further discussion? Seeing none, Mr. Kohler, please open the machine and members proceed to vote. Representatives Buckner and Wilson. Representative Buckner. Representative Buckner excused. Close the machine. With 62 ayes, no noes, and 3 excused, Senate Bill 198 is passed as amended. Madam Majority Leader.
Thank you, Madam Speaker. I move to add the following bills to the special order calendar. Senate Bill 208, Senate Bill 56, Senate Bill 200, Senate Bill 186, Senate Bill 104, House Bill 1343, Senate Bill 3, Senate Bill 143, Senate Bill 36, and House Bill 1468.
The motion is that the Majority Leader's list of bills be added to the special orders calendar. Seeing no objection, so ordered. We are now in special orders, taking special orders up again. Representative Primavera. You've heard the motion. Seeing no objection, Representative Primavera will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee amendments will not be read unless requested, as they are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads and not read unless requested. Bills will be laid over upon motion of the Majority Leader. The court rule is relaxed. Mr. Kohler. Please read the title of Senate Bill 203.
Senate Bill 203 by Senator Lambert, also Representatives Hamner and Rankin, concerning the evaluation of state tax expenditures in connection with making an appropriation.
Representative Rankin.
Thank you, Madam Chair. I move Senate Bill 203. There is no committee report.
For the bill, Representative Rankin. Representative Hamner, sorry.
That's
Corey
right.
was
Thank
in
you,
my
Madam
way.
Chair. Members, Senate Bill 203 is a joint budget committee bill. It puts in place a systematic process through which the state auditor will review all of our state tax expenditures. And the purpose would be to determine if the provisions are accomplishing the intended objectives. It puts in place a very fair and balanced system for looking at these tax expenditures on a regular basis. And I ask for a yes vote.
Is there any further discussion on Senate Bill 203? Representative Rankin.
And I also ask for a yes vote. We've very tightly structured this requirement to the Audit Committee to look at tax expenditures. 19 other states already do this report. It's something we need for good management. I ask for a yes vote.
Representative Pabon.
Thank you, Madam Chair, and I want to commend Representative Rankin and Representative Hamner for bringing this bill forward. This very well could be the most important bill we pass this session. And let me tell you why. The issue is tax expenditures. and the enormous impact they have on our budget, on our ability to fund our roads and our schools, our prisons, and everything in between. And this is a transparency bill of transparency bills. This sheds light on the tax expenditure situation that we have in this state. And over the course of several decades, I would say that we have put in law many different types of tax subsidies. But we don't have a good way of measuring the effectiveness of those tax expenditures, and this is a way to do that. So, in the interest of saving the taxpayers' dollars long-term, in the interest of shining sunlight on this issue, in the hopes that we have a way that we understand how our government should best effectively work, I ask for an aye vote.
Representative Court.
Thank you, Madam Chair. Here's a history question. How many of you remember Representative Joel Judd? Representative Judd, over a decade ago, suggested this. It has been suggested over and over and over again. Last session, Representative Casey Becker brought this bill forward. This is extremely important. Let's find out what bang for the buck we're getting, folks. We give away billions. That's with a B. Let's find out what we're getting for it. I strongly urge a yes vote and thank Representatives Hamner and Rankin and the entire JBC committee for bringing this. Thank you.
Is there any further discussion on Senate Bill 203? Seeing none, the question before us is the passage of Senate Bill 203. All those in favor say aye. Aye. All opposed, no. Senate Bill 203 is passed. Mr. Kohler, please read the title of Senate Bill 150.
Senate Bill 150 by Senator Stem and also Representative Esgar concerning marriages by individuals who are parties to a civil union in connection with prohibiting marriages in circumstances which one of the parties is already in a civil union with another individual, addressing the legal effect of parties to a civil union marrying each other, clarifying the dissolution process when parties to a civil union marry, and amending the bigamy statute to include parties to a civil union.
Representative Esgar.
Thank you, Madam Chair. I move Senate Bill 150.
To the bill, Representative Esgar.
Thank you, Madam Chair. Members, when we talk about cleanup bills, that's specifically what this bill does. Many of you were here in 2011 and 2012 when the civil unions bill was brought forward and failed. In 2013, civil unions finally passed. And thousands of Coloradans were able to actually enter into a legal commitment to each other. In 2014, marriage equality started in some of the counties across our state. Mine included in Pueblo. When that happened, there was great celebration, but there was also confusion. There were many people who had now decided to get a marriage license and weren't sure what to do with their civil unions. Do we have to pay to get a civil union dissolved? Does our civil union dissolve automatically into the marriage? Does my legal relationship start when the civil union started, or does it start when the marriage started? All of these questions started to brew. Then in October, the Attorney General instructed all clerks in Colorado to issue marriage licenses. So the problem even grew bigger. In June of 2015, I am proud that full marriage equality across the country, actually became law of the land. But we still had thousands of Coloradans confused about what exactly was happening with their civil union versus their marriage, and can they make sure that their relationship was legally recognized? That's what this bill does. This bill simply says if you were in a civil union with one person and you married that same person, your civil union is now dissolved into your marriage. And the date of your legal relationship started the day you signed the civil union. And that's important for if the marriage ever needs to dissolve, they can go back and see how long this legal relationship has been in play. This bill also prohibits anyone to have a civil union with one person and a marriage with another. Right now, there's a big loophole in Colorado law where that could happen. So when I say this is a cleanup bill, it is a cleanup bill. It's a cleanup bill to protect all marriages in Colorado. I urge an aye vote.
Is there any further discussion on Senate Bill 150? Representative Klingenschmidt.
Thank you, Madam Chair, and thank you, Representative Eskar, for your important work. I wasn't in committee, but I do have a question about the legislative declaration, which says this pertains to the Obergefell decision. And in the legislative declaration, on page 3, I'm reading lines 8, 9, and 10, it says, 5-4 Obergefell decision, the United States Supreme Court nullified a similar constitutional definition of marriage in Ohio for James Obergefell and other petitioners. But of course, we don't live in Ohio, and that Supreme Court decision was made for, I believe it was the 10th Circuit over Ohio, Kentucky, and a couple other states. Maybe it was some other. But I'm wondering, is the declaration announcing that this Supreme Court decision governs Colorado, or is it only governing Ohio in this declaration?
Representative Eskar.
Thank you, Madam Chair, and thank you, Representative Klingschmidt, for the question. And the answer is still within the legislative declaration where it says Senate Bill 150 does not address nor settle this concern.
Representative Klingenschmidt.
Thank you, Madam Chair. And yet, when I read the bill itself, I did find an interesting sort of an Easter egg. And I'm wondering, for those who didn't grab the statute book off of the shelf like I did, if you noticed a particular line in the bill that is being deleted. Now I'm referring to the House bill, page 4. Yes, the re-engrossed bill, page 4, line 20. And in order to talk about this more fully, I would like to move Amendment L011 and request it to be displayed on the screen.
Amendment L011 has been properly moved and is displayed on the screen. To the amendment, Representative Klingenschmidt.
Thank you, Madam Chair. So there is a section in this bill on line 20 that repeals existing law. Existing law in section 14-15-116 reads as follows. Reciprocity, principle of comity, a relationship between two persons that does not comply with this, basically in another jurisdiction like Ohio, is deemed in Colorado now to be a civil union as set forth in this article. So if you have a marriage in Ohio, current law says that is a civil union in Colorado. And now the bill before us is striking that reciprocity, striking that comity. So in other words, if the bill passes, a marriage in Ohio will now be a marriage in Colorado, not a civil union in Colorado. So it is bringing foreign marriage into Colorado, which is against the Colorado Constitution, and therefore I request a yes vote on Amendment L011.
Is there any further discussion on Amendment L011? Representative Leonard.
Thank you, Madam Chair. I would move a substitute amendment, L012, and ask it to be displayed.
Amendment L012, a substitute amendment to L011, has been moved, and it is properly displayed. Representative Leonard, please proceed.
Thank you, Madam Chair. This is a technical cleanup on this. This just strikes on page 4, line 20. It's the same issue, but shouldn't have been, line 21 shouldn't have been struck. It's the same issue of the laws in Ohio are not the laws here. This is a law that was struck of reciprocity, and I would urge a aye vote for this amendment.
Is there any further discussion on L012? Representative Klingenschmidt.
Thank you, Madam Chair, and thank you, Representative Leonard, for catching the technical distinction. You know, I was striking lines 20 and 21, but now your amendment only strikes line 20. And I think substantively it's the same, but technically yours is better than mine. So again, in the bill, members, this is important. The bill, if my amendment does not pass, or if Representative Leonard's amendment does not pass, the bill takes Ohio marriage and inserts it into Colorado marriage. But if my amendment fails and the bill passes, no, I got that backwards. So if none of this passes, if the bill fails, existing law says that if you have a marriage in Ohio and it comes to Colorado, those people move from Ohio to Colorado, that it's a civil union in Colorado. And so they're trying to strike that. We want to unstrike that. We would prefer to keep it, that if it's an Ohio marriage, that it becomes a Colorado civil union. It shouldn't be a Colorado marriage, because 3 times the Colorado voters have voted against that kind of marriage. And we're defending the Colorado Constitution, which has not been redefined by the Supreme Court Obergefell decision. As it even says in the legislative declaration, that only applies to Ohio, does not apply to Colorado, and the Colorado Constitution is still law, should still be enforced until there is a court decision saying otherwise. So our amendments are important. This is a definition. You're going to redefine the Colorado Constitution if these 2 good amendments fail. I urge a yes vote on the lettered amendment.
Representative Salazar.
Thank you, Madam Chair. Members, I rise in opposition to this amendment. What this bill does is this bill applies across the nation what the Supreme Court has said, which is that marriage, same-sex marriages, is constitutional, and anything otherwise would be considered unconstitutional. We have something called the full faith and credit clause of the United States Constitution, which means that whatever applies in one state also applies in another. And we have supremacy clause, so that means that a marriage that is recognized in Ohio will be recognized here in the state of Colorado. And that's why this is a cleanup bill, is because we need to make sure that we comply with the United States Constitution, which is supreme to the Colorado Constitution, whether you like that notion or not. I rise in strong opposition.
Representative Rosenthal.
You know, I appreciate, thank you, Madam Chair. I appreciate the efforts by some of my colleagues to help us pass this bill and to clarify the Constitution, which I always appreciate. But I think this actually kind of does the opposite. The whole point of the bill is to say that a marriage in one state is recognized in Colorado and vice versa. So this section that is in the statute speaks to how a marriage in one state is a civil union here. So we have to repeal that. That's the whole point of the bill, to clean up the statute so we have a marriage in one state is recognized as a marriage here. So I strongly do not support this amendment.
Representative Leonard.
Great. Thank you, Madam Chair. I do beg to differ with the whole point of the bill if it's to clean up the Colorado Constitution, because actually on page 3, and Representative Eskar pointed this out to us, that on line 18 it says the ultimate constitutional question of the United States Supreme Court constitutional jurisdiction and authority to redefine marriage in Colorado's Constitution through a ruling on certain individual cases in other states, i.e. Ohio, is a matter the General Assembly may take up at a different time, but Senate Bill 16-150 does not address nor settle that concern. This bill does not settle the concern about the redefinition of marriage in the state of Colorado. It clearly says it inside this bill, and this is just a clarification to make sure that that in fact Ohio's Constitution works for Ohio. Colorado's Constitution is very clear that if there's a marriage in another state, it's recognized as a civil union here in Colorado. That is not the issue for this bill, as it clearly says on page 3. Thank you.
Thank you, Representative Leonard. And if people could fill their plates again and eat some more so it'll be quiet in here. Representative Pabon.
Thank you. Thank you, Madam Chair. And I guess this is when we do need the lawyers down here, because there's some provisions of our Constitution that are archaic. And in fact, I'm pretty sure, I'd have to check the voting roll, that we just voted on one or will vote on one. Senate concurrent resolution 2 and Senate concurrent resolution, which one is it? Melton and 6. that says that we are no longer going to recognize involuntary solitude and slavery. That's what the Constitution says. But as a practical matter, that's not what the Constitution does. And what we have here is a supremacy issue. The United States Supreme Court has ruled on this issue. And whether we like it or not, whether we support the policy or not, that is the law of the land, and we took sworn oaths to uphold it. And so what this bill does is simply recognize that decision, implement it into law, says that the issue of the actual language or the issue of the implementation that we deal with is up to us to change, like my colleagues, Representative Melton, Representative Salazar, Representative Vigil, are all working on. But as a constitutional matter, as a civil rights matter, we are going to recognize that marriage is marriage no matter what state, and we are going to make sure that we have the same protections and the same rights for our Colorado citizens that everyone deserves under that Supreme Court ruling. So I adamantly oppose this amendment, and I support the bill. Thank you, Representative Esgar, for bringing it.
Representative Rosenthal.
Thank you, Madam Chair, and I really think that Representative Pabon just put it perfectly, so I'm going to try to restate what he said. Basically, I'm looking at this paragraph, and I really appreciate what the bill is trying to say. It's saying, look, we are not going to try to relitigate what apparently, let's just recognize a reality here. There is some disagreement about that court decision even today, about the Obergefell decision. It's a reality. We disagree on that, yet it is the law of the land. When the Supreme Court rules, it's the law of the land. It is one of the cornerstones of our Constitution and of our democracy. But we're not relitigating that. That's not the issue here. The issue is this complicated legal process of dissolving a civil union and a marriage for the same couple. That's it. We're not relitigating anything. What this amendment does is it strikes to that issue to try to confuse this, and it's not necessary. This amendment is not necessary. Quite frankly, a lot of this discussion here at the well right now is unnecessary. And so rather than say any more unnecessary words, I will stop here. Thank you.
Representative Klingenschmidt.
Thank you, Madam Chair. So now I've heard two conflicting stories from three members on this side. First, we heard from Representative Esgar, who read the declaration, which said, well, you referred to it, and it says, this bill doesn't redefine marriage under the Obergefell decision because that, let me just read the declaration. It says, the United States Supreme Court's constitutional jurisdiction and authority to redefine marriage in Colorado's Constitution through a certain ruling of individuals in other states is not decided in this bill. It is something for the General Assembly to take up at a different time. So if Representative Esgar is saying, no, the Supreme Court decision is not being enforced in Colorado through this bill, but then we heard from Representative Salazar and Pabon, it is being enforced in Colorado through this bill. And in fact, Representative Leonard identified properly the section of the bill that is now enforcing an Ohio decision. It's not the law of the land. It is the law of Ohio, according to the Obergefell decision, which had jurisdiction over the Ohio and 3 other states in that circuit. So which is it? Are we applying this Supreme Court judicial supremacy over the state of Colorado through this bill, or should we pass this good amendment and repeal that part which would try to enforce the Supreme Court decision over the state of Colorado? This is an Ohio law. Let's not bring it into Colorado yet. And not to relitigate, but somebody's got to relitigate. Somebody's got to take this decision to a Colorado court before the Colorado Constitution can be changed. The voters voted 3 times that the Colorado Constitution says this. Well, twice they said this, and once they tried to repeal it and failed. So 3 times the voters said what the Colorado Constitution says. And now this bill is trying to say otherwise. This is wrong. And your side is self-conflicting. The bill is self-conflicting. This amendment brings clarity. I urge a yes vote.
Representative Escar.
Thank you, Madam Chair. Members, I urge a no vote on this amendment.
Representative Leonard.
Thank you, Madam Chair. I did not write this language here that says this bill, Senate Bill 16-150, is intended to remedy the complicated legal process of dissolving a civil union and a marriage for the same couple. That's what this bill is for. So simply put, that's exactly what this bill is for. It says the next sentence that this bill says is the ultimate constitutional question of the United States Supreme Court about redefining marriage in Colorado. It is not addressed in this bill and does not settle that concern. Rightly so, it doesn't. And so therefore this amendment makes sure that this language that says in the bill is followed according to what the bill says. It's there to do a very simple job, as the sponsors have said, and redefine that. It's not here to get into the Constitution and to dive into it, which is why this current language in the Constitution needs to remain in effect, that Colorado remains in autonomy, and yet this bill can, in fact, solve the issue of the dissolving of a civil union and a marriage of the same couple. So I urge a yes vote on this amendment.
Is there any further discussion on Amendment L012? Representative Klingenschmitt.
Thank you, Madam Chair. Just one last thing. I want to read the existing law that their bill is trying to repeal that our amendment would put back in. This is what the existing law says. Under the principles of comity, a legal relationship, for example, marriage between 2 persons that is legally created in another jurisdiction, like Ohio, shall be deemed a civil union for purpose of a Colorado law as set forth in this article. So the existing law, if you have some kind of marriages in Ohio, but those people come to Colorado, it's a civil union. And they want to repeal that? They want to say that an Ohio marriage is now a Colorado marriage? The voters did not authorize that. The Colorado Constitution does not authorize that. We've even heard, and Representative Leonard read twice now from the declaration, in this bill, it says they're not trying to authorize that. But surprise, surprise, we found an Easter egg. When you pull it off the shelf and actually read the statute that I just read, they are trying to bring Ohio law into Colorado. They are trying to appoint and apply the Obergefell decision, which is limited to some states. They are trying to apply that to the state of Colorado and therefore subvert the will of the voters and the Colorado Constitution. We swore an oath to defend the Constitution. I urge a yes vote on this amendment.
Is there any further discussion on Amendment L012? Seeing none, the question before us is the passage of Amendment L012. All those in favor say aye. Aye. Opposed, no? No! Amendment L012 is lost. We're back to Amendment L011. Representative Klingenschmitt.
Thank you, Madam Chair. For the same reasons, I urge the passage of Amendment L011.
Is there any further discussion on Amendment L011? Seeing none, the question before us is the passage of Amendment L011. All those in favor say aye. Aye. Opposed, no? No! Amendment L011 is lost. To the bill, Representative Escar, any further comments?
Thank you, Madam Chair. Members, this bill truly is about cleaning up language. People move here from another state that have a marriage somewhere else shouldn't have to jump through loops or hoops, whatever this saying is, sorry, loops in the law or jump through hoops figuratively to make sure that legally their relationship is recognized. It's the law of the country, granted by the decision that came out of the Supreme Court. I waited. My wife and I have been together 6 years, going on 7, and I wanted to marry her the day I met her. I waited until I knew that my marriage was legitimate and recognized across the entire country. That's why we made the decision to get married after the Supreme Court decision came down. Why would we make it harder to welcome in people who want to move to Colorado? Why would we make them jump through the hoop of you have to get a civil union first? This is about making sure that everybody's marriage is equal in the state of Colorado. The Attorney General believes so. Our county clerks issued licenses, and the Supreme Court of the United States of America ruled that this is how it should be. This bill is cleaning up our language to make sure that all Coloradans are welcome. I urge a yes vote.
Is there any further discussion on Senate Bill 150? Seeing none, the question before us is the passage of Senate Bill 150. All those in favor say aye. Aye. Opposed, no. Senate Bill 150 passes. Mr. Kohler, please read the title of Senate Bill 146.
Senate Bill 146 by Senator Stem and also Representative Esgar concerning modernizing statutes related to sexually transmitted infections.
Representative Esgar.
Thank you, Madam Chair. I move Senate Bill 146 and the Public Health Care and Human Services Committee report.
To the Public Health Care and Human Services Committee report.
Thank you, Madam Chair. In the Public Health Services and Public Health Care and Human Services Committee report, we passed 2 amendments. One of them was brought forward by the chair of the committee to make sure that we included age on the reasons why we would not discriminate, knowing that the aging population may also be susceptible to sexually transmitted infections. And we also passed another amendment to make sure that the original language of the bill that was concurrent with current statute was actually put back in place. I ask for an aye vote.
Is there any further discussion on the Public Health Care and Human Services Committee report? Seeing none, the question before us is the adoption of the committee report. All those in favor say aye. Aye. Opposed, no. The Public Health Care and Human Services Committee report is adopted. To the bill, Representative Esgar.
Thank you, Madam Chair. Members, this bill seeks to modernize our statutes when it's related to sexually transmitted infections. We know medicine has come a long way since our statutes were last updated. This bill is meant to help expand public health orders and procedures when it comes to STIs, and it actually expands the rights of crime victims and first responders to be tested for STI exposure for improved standards of care. This bill had extensive stakeholder work with over 200 people and hundreds of hours put into it. Colorado Department of Public Health, Children's Hospital, and many others are in support of this important legislation. I ask for an aye vote.
Is there any further discussion on Senate Bill 146? Representative Joshi.
Thank you, Madam Chair. Members, I rise in opposition of this bill. This bill has several issues. First of all, it's all about parental rights. This bill takes away the parental rights. It basically says a doctor may, or any healthcare provider who is taking care of minor patients, may contact the parents. I think that's really a very bad idea. These kids, they don't know what is going on. I think it's very important if they are going to be under their parents' care. The parents have every right to know what is going on with their health care. That was number 1 issue. Number 2, it also says that the medical providers will be given immunity. But I will tell you that if somebody comes and you take care of them, you give them medicine, they can have any kind of reactions. What happens if they have severe allergic reaction and end up in emergency room or being admitted in the hospital? You know that whether you have immunity or not, I mean, we have many attorneys here, that person will be sued, regardless whether you have immunity or not. So it is very, very important that we continue to make sure that the medical provider shall actually notify the parents. So I ask for no vote on this bill.
Madam Assistant Minority Leader.
Thank you, Madam Chair. And I did not hear this bill in committee, so I apologize if this question has been asked and answered. But my understanding is that this bill is a repeal and reenactment of current statute. So could you just clarify that for me?
Representative Escar.
Thank you, Madam Chair, and thank you, Representative Lawrence, for the question. That is exactly what this bill does. It repeals and reenacts current statute. That's what it does. It's what is part of statute and in law now.
Madam Assistant Minority Leader.
Thank you, Madam Chair. So is the amendment that is being discussed right now, does that change what is currently in statute, or is that putting it back to what was in statute?
Representative Escar.
Thank you, Madam Chair. In committee, we ran an amendment to fix a Senate amendment that came on to the original bill. The original bill was what is current statute, and we wanted to make sure that we made the amendment we passed in committee put it back to exactly what is in current statute. Clear as mud? Thank you.
Is there any further discussion on Senate Bill 146? Representative Everett.
Thank you, Madam Chair. We did hear this bill in committee ad hominem, long time. And I think Dr. Joshi, Representative Joshi, the crux of what he was talking about goes back to the may versus shall language. We heard that that's aligning with current federal statute, but let's just look at this from a practical standpoint. And let me appeal to those parents out there that have kids. So basically, with the change that we got in committee of changing shall notify the parents when your child is going to get treatment, your underage child, 13 or under, it's been changed to a may. They have no responsibility to tell the parents when your kids are getting some sort of treatment, some sort of medical treatment. So what could happen in this situation? Your child gets treatment for an STD, you don't know about it. They are scared, so they're not going to say, I might be allergic to this medicine, or they may not even know because they're 12 or 13 years old. They go into anaphylactic shock, and they go into a coma. With this language, they're not obligated to tell the parents that this has all happened with this current language. This is a very dangerous bill. This interferes greatly with parental rights and the parent-child relationship. I urge a no vote.
Representative Danielson.
Thank you, Madam Chair. I also serve on the committee where we debated this bill. And I just wanted to read the part of the bill that this amendment addressed. It says, if the minor is 13 years of age or younger, the healthcare provider may involve the minor's parents or legal guardian. It also says, a healthcare provider shall counsel the minor on the importance of bringing his or her parent or legal guardian into the minor's confidence regarding the consultation, exam, or treatment. 13 years or younger. So we heard from the folks who treat these young people when they present after wondering if they need treatment. And they said across the board, the current statute, which is what this amendment brought this bill back into line with, is functioning properly. And the way that it does that is when a young person presents, if they have not told their parents, they receive treatment. However, they, through the process, counsel the minor that the best course forward, if at all possible, is to bring the parents into the conversation and the subsequent treatment. And almost all of the time, they said 99% of the time, the parents are involved in these decisions by the end of the process, as this bill would require. So what about the small percentage of parents who aren't brought in to the situation? These are very real, very dangerous cases where there is a severe reason that a minor cannot consult their parents on the front end. We're talking about a kid who may not have a guardian. They may not have a home. The STI that they probably contracted could be a result of rape, incest, in a situation where this kind of abuse is at the hands of a parent, an uncle, a legal guardian, a sibling, whomever it is. There's a reason that they cannot involve their parents, which is far more dangerous than requiring them to involve their parents. So this aligns this bill with current statute, which we heard across the board is working to serve the kids across the state in an adequate and careful manner that provides the best health care, the best treatment for these kids, and the requirement that they counsel the minor on bringing the parents in usually results on them bringing their parents into the conversation. When it doesn't, there's a real and scary and terribly dangerous reason why they can't. As far as the scenario where an allergic reaction could cause the minor some healthcare problems for treatment, such as if the kid was allergic to penicillin or something like that. But we also heard in committee that this, under current law, again, what this would bring the bill into, current law is that they may involve the minor's parent, not that they may not. Okay, so they may involve the minor's parents, not that they may not, meaning there are certain circumstances where they have to notify the parents. For example, if the child had a severe allergic reaction to medication they received for treating an STI. Further, they reminded the committee that these are healthcare providers, these are doctors, these are professionals, and when they are treating for STIs, there's a series of questions that they go through with the patient to discover these kinds of issues. So for the reasons that I just described, one, that this aligns this bill into current statute, B, that the system that's in current statute is working, and C, for the reasons that I described where the few kids who cannot tell their parents about what's happening to them is that there are real and severe and terrible reasons that they cannot. So for those reasons, I supported the amendment, and I urge your aye vote on the bill.
Representative Janal? No? Representative Everett?
Thank you, Madam Chair. And as Representative Danielson pointed out, it's still may. They may. Standard practice may be one thing, but they're still not required to under the statute. Now, when it comes to the rape and incest, absolutely. When it's danger to the child, we should handle that. But why don't we have clarifying language that, let's say when the healthcare provider, the person providing the treatment, suspects or the child claims that there is some abuse or something of that nature, that's when it triggers where you shall not inform the parent. But that's not in the bill. Currently, whether it's practice or not, a doctor can choose not to inform the parent when your child is getting treatment. We're talking 12 and 13-year-olds. So it said shall counsel, but if you're a scared 12 or 13-year-old, you're not going to go, you don't want mom and dad to find out that you maybe did something, that may be considered bad or you might get in trouble. So it has no effective law, but still, again, it's only may inform the parent. Again, this interferes with the parent-child relationship. It takes away personal responsibility. And this is, again, government interjecting itself in that parent-child relationship. I urge a no vote on this bill.
Representative Janal?
Thank you, Madam Chair. I rise in support of this bill. In a perfect world, and that's what it sounds like we're all talking about, a perfect world where there's parental advice and kids are communicating with their parents. What's in statute and what would be in statute is may, because there are, as other people have stated in support of this bill, there are children under the age of 13 who don't have parents understanding, who don't even have a home. And that's why the current statute should stand as may, because it's those children, that small percentage, that this bill is addressing in regards to the issue of parental consent or lack thereof. In a perfect world, you're right, but this isn't a perfect world. So I ask your support of this bill.
Representative Tyler?
Thank you, Madam Chair. Members, 1970, a long time ago, I worked at Colorado Psychiatric Hospital. I was on the adolescent ward. It's quite a place to work for my first real job out of school. And I took family histories. I took histories of families that went through 3 generations of incest and abuse. It is not unknown. It's not unknown by any means. There was an institution called Florence Crittenden Home for Unwed mothers, which is how they treated those things back then. And the people there made it pretty clear that girls, and I will say girls, 14 and under, that they saw there, upwards of 75% of them or more were pregnant as a result of their mother's boyfriend or an uncle or their father. Now, everybody doesn't live in a world with a nice white picket fence. Everybody doesn't drive a BMW. Everybody doesn't have great success in the world. There's a significant number of children that are abused by people they trust, most often by a mother's boyfriend. That's why the statute is what it is today. We don't all live in a nice middle-class world. We don't all live in the kind of world that the people here, for the most part, live in. There's been long history of abuse and sexual assault by close relatives. And when you're in that situation, can you imagine being a 13-year-old and trying to deal with that? Can you imagine being a 13-year-old and somebody's telling you, well, you have to take responsibility for the fact that you've had a dysfunctional family for the last 3 generations, and they're protecting the abusers in this family, because that's what happens. That's why the statute is written the way it is. That's why it needs to say that it is, to protect the children. Please vote yes for this bill.
Representative Leonard.
Thank you, Madam Chair. I think all of us in this body realize that we're not stereotypical, that the rest of our district and the rest of our state is not stereotypical of ourselves, our families, and even our neighbors. I think we realize that there's a lot of difficulties in the world, and I think we spend 90% of our time here at the legislature talking about that 90%, that 10%, I should say, that needs extra care and extra help. I don't think anyone is denying that whatsoever. And if truly this bill were written to acknowledge that there's a perfect world out there and then there's an imperfect world, it would say shall, but with the exception that if there are difficulties at home, then you may or may not exercise your advice to be able to bring parents in, but it doesn't. It groups everyone in and says, even if you come from a wonderful family, but you're showing up here at our clinic at 12 years old, unbeknownst to your parents, with a very traumatic physical issue that brings emotional strife with it also, we will counsel you and tell you that you ought to bring in your parents, but we're not going to do anything more than that. That's not strengthening families. That's separating parents from children at a time when they need their family and the parents the most. And I'm not talking about that 1%, because we can easily say that 1% with incest and problems at home. Those people don't need any more problems. But what we're talking about here is every single person, every single minor that walks through this doorway into here has no requirement by that provider to be able to tell that child, you need to strengthen with your family. Let me read the issue that's larger here on page 14, line 23. This is the extension of what happens. If a minor requests, so here's a 12-year-old requesting prevention services, a diagnostic examination, care, prevention, or treatment for a sexually transmitted infection, that healthcare provider can give a vaccination, a shot, some medical aid into that child's body without ever having to consult the parent. Now, we've heard, well, there's some questions you can ask a 12-year-old. We can take blood type, obviously, but the 12-year-olds that I know are not going to be able to answer any medical questions, especially under this circumstance. But here's the real key for why this bill doesn't help this child out, this this pressure of shall versus may. Because the next sentence says that here's this provider that runs to the aid who provides such services. This healthcare provider is not civilly or criminally liable for performing the service, but the immunity from liability does not apply, obviously, to a negligent act or omission. So this person who rallies around this child to give them medical injection is not there for them should there be any criminal or civil problem that comes up with this child. They have complete immunity. That is not strengthening the family. That is not helping the child. So what I would ask the sponsors, the same thing as what the Senate asked, to be able to change may to shall so that the parents will be informed. You can put in exclusionary language for those 1 or 2% of the non-perfect worlds, but strengthen the family by being able to inform the parents of what crisis this child is going through before administering medical care. Thank you.
Madam Assistant Minority Leader.
Thank you, Madam Chair. Members, it's been brought to my attention that the website that gives the votes for this bill shows that it came out of the Judiciary Committee unanimously. That vote was just to move it from Judiciary to the Health Committee. I just wanted to clarify that for everybody's information because apparently I'm getting questions about having voted on this in committee and we didn't do that except to move it to another committee. So I just want to clarify that.
Representative Eskar. Representative Danielson.
Thank you, Madam Chair. Again, I just want to focus back on what we're talking about here. It was suggested that we could include quote-unquote exclusionary language to only require or to not require this discussion with the parents if it was one of the scenarios that I described before where the child is a victim of rape, incest, abuse, or neglect, and they were seeking treatment for these illnesses because they had been abused, neglected, assaulted, raped, etc. But we're talking about kids that are 13 years or younger. So again, how many of these kids are choosing to have sex? And if you put in their exclusionary language, then you're putting that judgment call on the shoulders of a child to determine whether or not a law is being broken in their home. It doesn't make logical sense in a real live household where a real kid is the victim of a real terrible crime. It impairs the ability for the doctor to provide adequate medical care because it hinges on the approval of a parent that may or may not be there or may not be the reason that the kid is being neglected or abused. So for those reasons, this is really the only way that we can bring this statute into line. Also, if we change this to a shall, which again, I would not endorse, but it would also put us at odds with the federal HIPAA requirements. So that's another whole completely different problem, which would put us in a lot of danger. So again, that's why we voted to adopt the amendment in committee. That's why all the healthcare providers, the hospital workers, the departments who oversee this kind of activity, that's why everyone was okay with this and why I urge an aye vote.
Representative Neville.
Thank you, Madam Chair and members. I've got concerns with this bill. You know, we obviously it's already illegal. It's already a criminal offense to knowingly infect someone with the disease. This bill goes pretty far. You know, we hear a lot of talk in this legislature about a lot of stuff. And if you look on page 20, it actually says that the state can direct a person with a sexually transmitted infection to cease and desist from specific conduct. Where are we getting at with this? Where are we getting at with this language? Please, stay out of my bedroom.
Representative Eskar.
Thank you, Madam Chair. Members, this is a very important bill. Whether we debate if the word should be may or shall, it's current law, it's current statute. Not only is it part of our state statute, it's part of HIPAA. HIPAA states that under HIPAA, if a minor can lawfully consent to health care service without consent of another, and the minor consents, the minor then has the authority to control that consent. Even though a state law requires a disclosure from a covered entity, HIPAA states that a covered entity may disclose to the parent or guardian. May. That's federal law. The language that is before you in the re-engrossed bill is the language that it needs to be concurrent with current statute. That's what we're trying to do. We're trying to update every statute. May is what current statute is. May is what HIPAA asks for. May is what we are asking for in this bill. We're trying to align all of the different parts of the statute. That's why the bill is so long. We're coming together. We're threading the needle. We're finding all the spots that need to be modernized. Denying services to anyone shall puts a barrier in front of anyone who is looking for these services. We need to prevent these diseases from happening. We need to stop the spread of any of these infections from happening, and we don't do that by putting roadblocks up for anyone. Again, I urge a yes vote on this bill.
Is there any further discussion on Senate Bill 146? Representative Leonard.
Thank you, Madam Chair. That's one of the reasons why the bill is so long. And I completely understand that that there's motivation to be able to align ourselves with the almighty federal standards. But I'm trying to make the case that it's better for the family and for the child to not have something as weak as may, but have shall and then have caveats excluding difficult circumstances. But let me move on to another issue that does make the bill so long, and I think one of the sponsors pointed out, because we, quote, need to be able to stop the spread of sexually transmitted diseases, and of course that's important for our society not to do that, and it's acknowledged on page 21 that there is specific conduct that does spread that disease that's not good for society. And of course, this bill comes all the way 360 degrees to say that if someone is engaging in a promiscuous conduct and has been tested for STD and does in fact possess it, then they shall cease and desist, as it says on page 21, line 3, actually line 2, that the executive director or the local director of the public health agency may enforce the cease and desist order by imposing such restrictions upon the person as are necessary to prevent the specific conduct that risks the public health. Now, I'm not sure what all that means, but I got a feeling, since I do know where babies come from, that this specific conduct is going to be ordered to cease and desist by the government on an individual. Now, I thought it was many moons ago that we had plenty of complaints that laws that prevented conduct that spread diseases were outlawed a while ago. And I think Representative Neville said, stay out of my bedroom. I'm not sure, and I would ask the sponsors, how is this going to be enforced? The language in this bill that in order for an individual to cease and desist from specific conduct that risks the public health, I would ask that question, please.
Representative Escar.
Thank you, Madam Chair, and thank you, Representative Leonard. Those are specifically public health orders, and they are enforced after heard by a court. That's why that language is in there. They're current public health orders, and it takes, after they are heard from a court, that's when they cease and desist.
Representative Leonard.
Thank you, Madam Chair. Not exactly my question, but I understand the order comes from the court because I think there's a couple of pages exactly the due process that comes along and says that this person is a risk, this person acknowledges that they're a risk, they engage in conduct unbecoming to a person that has a sexually transmitted disease. The court does rule on it. The court does issue a cease and desist order, and now the local director can enforce that cease and desist order. That's the part that I'm not understanding, how the director enforces a cease and desist order to prevent the specific conduct in this bill.
Representative Escar.
Thank you, Madam Chair. Representative Leonard, this is a public health issue. So the director of the Colorado Public Health Department is the person who should decide, not somebody without medical knowledge. We want to make sure somebody with the medical knowledge is the one who's deciding if this should actually go before the courts for the cease and desist order.
Representative Leonard.
Thank you, Madam Chair. My question, public health, if we had an issue of infection, we would have quarantine. We would say you can quarantine the person. I would like to know, are we putting these people in solitary confinement in a jail? Are we quarantining them? Are we putting them under house arrest? What are the ramifications for our constituents that violate this bill? Are they going to jail? I'd like to know exactly. This law says, this bill proposes that a cease and desist order can be issued on someone because of specific sexual conduct. And I want to know, is that going to be a quarantine, prison, jail, solitary confinement, house arrest, or something else that is going to prevent this spread in our society?
Representative Escar.
Thank you, Madam Chair. No. This gives you right to counsel, right to an attorney, and right to court review. This doesn't put you in a jail cell.
Representative Conti's been waiting while. Representative Leonard.
You want to finish?
You want to let Representative Leonard go ahead? Representative Leonard.
Thank you, Madam Chair. The purpose of this bill, as it said in the declaration, is to prevent the spread of sexually transmitted infections. Going to court, having counsel, having due process doesn't do that. It prolongs a very long legal process, but it does not specifically get to the issue. We talked a lot in this bill about what we can do to minors. We can give them injections, we can give them counseling, we can give them preventative measures. We can or can't talk to their parents, but we don't say how this bill is going to prevent the spread of sexually transmitted diseases, even though it barks all about cease and desist orders. Does it actually do something? That's what I'm interested in.
Representative Conti. Representative Joshi.
Thank you, Madam Chair, and thank you, Representative Leonard, for bringing that issue. I think it's a very important issue. Public Health Department always have, and if you remember, we have argued on some other bills that they can put you in quarantine because they want to prevent spread of these diseases. If there is a big outbreak, you are right. So if that happens, they will do that. And if they do that, how could you put a 12-year-old in almost like a prison-like situation without telling the parents why you did it, what was going on? I think this bill is actually looking like a lot of issues here that one by one coming out. And I don't think this is the right way to take care of our young children. I think the parents have every right to know what is going on and let them make that decision. So again, I ask for no vote on this bill.
Representative Conti.
Thank you, Madam Chair. Representative Salazar, I believe that you were talking about the constitutionality of this and talking about the aligning with federal statute. Am I correct? No, you're not? Oh, sorry. That was... Things are moving so quickly, I must have gotten confused. All right, well, I think we were talking about aligning with federal statute and that we were removing the word shall in order to align with federal statute. But correct me if I'm wrong, we have the ability as a state that we can make our policies more stringent than the federal code. And I believe this is a perfect example of what the Senate was trying to do here. They were trying to assert our state's rights to be a little bit more stringent than the federal code. Why is that a problem?
Representative Everett.
Thank you, Madam Chair. I do believe that Representative Conti is right, that HIPAA is actually a floor, not a ceiling. So we are not restricted in what we can do. So having this extra restrictive language, putting the shall in there, actually letting parents know what's going on with their kids, I think is stronger language that's just better for the state of Colorado.
Is there any further discussion on Senate Bill 146? Representative Joshi.
Thank you, Madam Chair. There are some other issues in the preventative aspect. We are also talking about aligning with the federal statute. So when you give vaccine to somebody, you have to actually align with the federal statute. But federal statute says that you have to inform the parent. So I move Amendment L019 and ask it to be displayed.
Thank you. Amendment L019 has been moved and it has been properly displayed. Please explain the amendment, Representative Joshi.
Thank you, Madam Chair. Well, this amendment is quite self-explanatory, as it says that if a healthcare provider administers a vaccine to a minor in the process of providing care, preventative services, or treatment for sexually transmitted infections, the healthcare provider shall provide, prior to the administration of the vaccine, the minor's parent or legal guardian with appropriate risk and benefit information related to the vaccine in compliance with the federal National Childhood Vaccine Injury Act of 1986, 42 U.S.C. .sec.300A, etc. So what this basically does, it just puts this bill in line with the federal statute. And I think that's what we are trying to do here, as we have been hearing, that we are trying to align a lot of these things with the federal statute. So I think this makes sense, and I ask for a yes vote.
Is there any further discussion on Amendment L019? Representative Everett.
Thank you, Madam Chair. Obviously, looking at another part of federal statute, here we are, shall inform. Shall inform. The standard is there in federal statute, something we can do with this bill to make it stronger and put parents first and make sure our kids are taken care of. I urge an aye vote on this amendment.
Representative Eskar.
Thank you, Madam Chair. Members, I urge a no vote on this amendment. This is one more barrier in somebody's way of getting treatment for an infection. We want to stop these infections, and we want to stop the spread of infections. This is one more barrier to go. I vote no.
Representative Humphrey.
Thank you, Madam Chair. And I find that problematic to refer to this as a barrier. Parents are not a barrier to health care. I think it's critical that we comply with federal law and that parents be notified. They are not a barrier to their child's health care.
Representative Leonard.
Thank you, Madam Chair. I know we've heard on the shall and mays, we're aligning with federal statutes, and here is a prime example of just informed consent in the vaccination process, and we clearly have in this bill that the treatment could very well have injections. And so I see no reason that informed consent for a treatment of this nature would not both align with federal statute, which is obviously important to some, and protect the child for those of us that are most concerned about the health benefit and welfare of the child. And I think, again, I know we're trying to address this 1 or 2%, that the parents aren't there, and don't understand enough about what this informed consent would be, but I venture to say that a vast majority of our constituents as parents are very concerned about having informed consent about injections that would go into their child. And so I would impress upon you to vote yes for this amendment. Thank you.
Representative Joshi.
Thank you, Madam Chair. And members, I disagree that this is a barrier. I think it's a good medical practice. If you are going to give vaccine which potentially can have side effects, I think we want parents to know about it and give them all the information they need so that the decision can be made. And again, all we are doing is aligning with the federal statute. So I ask for yes vote on this amendment.
Is there any further discussion on Amendment L019? Seeing none, the question before us is the passage of Amendment L019. All those in favor say aye. Aye. All those opposed, no? Amendment L019 is lost. Is there any further discussion on Senate Bill 146? Representative Neville.
Thank you, Madam Chair. And I just have a question for the sponsors regarding page 17, line 17. It says a pregnant woman seeking prenatal care must be informed that syphilis and HIV testing are part of standard prenatal testing. Is there a reason that we need to put the force of government into prenatal care?
Representative Eskar.
Thank you, Madam Chair. Same verse, second verse, same as the first. This is current statute. When a woman is getting prenatal care, her blood is taken and tested for syphilis and for HIV.
Is there any further discussion on Senate Bill 146? Representative Danielson.
Thank you, Madam Chair. It's just clarifying that if they hadn't, if they didn't seek this kind of medical care previous to them going to deliver, that they would then need to be tested, and it's a health precaution, and it's standard practice.
Is there any further discussion on Senate Bill 146? Seeing none, the question before us is the passage of Senate Bill 146. All those in favor say aye. Aye. Opposed, no? No! Senate Bill 146 passes. Mr. Kohler, please read the title of Senate Bill 19.
Senate Bill 19 by Senator Cook, also Representative Stain and Foote, concerning a requirement that court-ordered mental condition examinations be recorded in connection therewith, making an appropriation.
Representative Stain.
Thank you, Madam Chair. I move Senate Bill 19, and I move the Appropriations Committee report.
To the Appropriations Committee report.
Thank you, Madam Chair. The Appropriations Committee report, they added an appropriations amendment. I urge a yes vote.
Is there any further discussion on the Appropriations Committee report? Seeing none, all those in favor of the passage of the Appropriations Committee report, please say aye.
Aye.
Opposed, no? The Appropriations Committee report passes. Representative Stain.
Thank you, Madam Chair. Members, Senate Bill 19 is a very good transparency bill. Current law allows videotaping and mental health examinations pursuant to the court's discretion. The bill seeks only to require that all court-ordered mental health examinations be videotaped in order to guarantee consistency in the process and to provide the best record and evidence in any given case.
Representative Foote.
Thank you, Madam Chair. This actually provides the best evidence that we can provide in these mental health cases, pleading by the reason of insanity, and the jury can see the best evidence, so we ask for an aye vote on this.
Representative Stain.
And just as videotaped interrogations promote ethical use of techniques, videotaped forensic interviews encourage the same professionalism in mental health examinations. I urge a yes vote.
Is there any further discussion on Senate Bill 19? Seeing none, the question before us is the passage of Senate Bill 119, or Senate Bill 19. All those in favor say aye. Aye. Opposed, no? No! Wow, Senate Bill 19 still passes.
All right, congratulations.
Yeah, good job. All right.
Mr. Kohler, please read the title of Senate Bill 35.
Senate Bill 35 by Senators Johnson and Sonnenberg, also Representatives Rankin and Young, concerning the public school fund in connection with creating a public school fund investment board to direct the state treasurer on the investment of the fund and changing the distribution of the interest or income earned on the investment of the monies in the fund.
Thank you, Mr. Kohler. Representative Young.
Thank you, Madam Chair. I move Senate Bill 35 and the committee report from the Appropriations Committee.
To the Appropriations Committee report.
Thank you, Madam Chair. Simple amendment to clarify the payments are made by the treasurer and that the General Assembly will take the board's recommendations into consideration when specifying the use of interest and income. I ask for your aye vote on the Appropriations Committee report.
Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is a passage of the Appropriations Committee report. All those in favor say aye.
Aye.
Opposed, no. The Appropriations Committee report passes. Representative Rankin.
Madam Chair, to the bill. This bill concerns the State Land Board and the State Permanent School Fund, which is set up with proceeds from the Land Board. In case you don't recall, the Land Board proceeds are split between the BEST program, the Building Better Schools, and this fund. There's about $1 billion in this fund, and it's been gaining about 3% because it's restricted to very low-risk securities. This bill sets up an investment board, allows that board to take a more aggressive investment strategy, and will in fact result in about $40 million a year in additional returns based on current speculation, or I shouldn't say speculation, on current estimations. So it will be a real shot in the arm for our school budgets of $40 million. And the bill also lays out the distribution of funds. First $21 million out of proceeds of the fund, as in current statute, goes to schools. The next $20 million to BEST, and the rest is at the discretion of the General Assembly. So it's a really good bill. Should have been done a long time ago to increase returns on these funds. Don't know why it wasn't, actually. So urge your yes vote.
Is there any Representative Everett?
Thank you, Madam Chair. I move L012 and ask that it be displayed.
Amendment L012 has been moved and is displayed. Please explain Amendment L012, Representative Everett.
Thank you, Madam Chair. Actually, we worked with the bill sponsors, stakeholders, everybody involved, even checked with the Treasurer's Office. What this amendment does, it tightens up the language a little bit on the investment. So it kind of takes a little bit of the risk out of there and makes sure that we get the maximum amount of return. Basically, that the investment choices that we have include mutual funds, index funds, and any instrument that may be a direct investment. So this allows us some flexibility into actually craft our own financial tool that might be unique to Colorado that gets us the maximum amount of return with the lowest amount of risk. I believe it's a friendly amendment. Yes. So, well, semi-friendly. Well, it is an Everett amendment, but yes, this one actually is friendly. So I urge an aye vote.
Representative Young.
Thank you, Madam Chair. And indeed, this is a friendly amendment. And thank you, Representative Everett, for working this through with us. I appreciate it.
Is there any further discussion on Amendment L012?
Even the treasurer likes this amendment and believes it improves on the strategy. So thank you, Representative.
Thank you, Representative Rankin. Is there any further discussion on Amendment L012? Seeing none, the question before us is the passage of Amendment L012. All those in favor say aye.
Aye.
Opposed, no. Amendment L012 passes. Is there any further discussion on Senate Bill 35? Representative Everett.
Thank you, Madam Chair. Again, this is actually not just a good bill, it's a great bill. Like Representative Rankin said, we should have been doing this a long time ago. This is actually innovative investment strategy to make sure we get more money for schools without raising taxes with the usual suspects. Great bill. Please vote yes.
Is there any further discussion on Senate Bill 35? Seeing none, the question before us is the passage of Senate Bill 35. All those in favor say aye.
Aye.
Opposed, no. Senate Bill 35 passes. Mr. Kohler, please read the title of Senate Bill 69.
Senate Bill 69 by Senator Garcia, also Representative Pabon, concerning measures to provide community-based out-of-hospital medical services in connection with making an appropriation.
Mr. Assistant, or Mr. Speaker Pro Tem. Madam Majority Leader.
Thank you, Madam Chair. I move to lay over Senate Bill 69 by one bill.
As requested by the Majority Leader, Senate Bill 69 will be laid over one bill. Mr. Kohler, please read the title of Senate Bill 87.
Senate Bill 87 by Senator Baumgartner, also Representative Tyler, concerning funding for the Highway Rail Crossing Signalization Fund in connection with making an appropriation. Representative Tyler.
Thank you, Mr. Chair. I move House or Senate Bill 87 and the Appropriations Committee. Is there an Appropriations Committee?
Representative Tyler, I believe you have a Transportation Committee report.
That's it, the Transportation Committee report.
To the Transportation Committee report, Representative Tyler.
Thank you. The Transportation Committee report helped harmonize the two different bills that are going forward to make sure that they get paid out in the correct order. Pretty straightforward.
Is there further discussion on the Transportation Committee report? Representative Neville.
This Transportation Committee report might be the most irresponsible thing I've ever seen. No, I'm just kidding. I'm actually okay with the committee report.
Is there further discussion on the Transportation Committee report? Seeing none, the question before us is the passage of the Transportation Committee report. All those in favor say aye. Opposed, no. The Transportation Committee report is adopted. To the bill, Representative Tyler.
Thank you, Mr. Chair. Senate Bill 87 is a pretty straightforward bill. It makes some small changes so that we can do a lot of good work in creating safe crossings for mostly for rural Colorado. This is something that's under the PUC jurisdiction. It was kind of left behind in the dust a few years ago because we're kind of running out of money again, which we seem to do. And so this one is going to be moving forward and helping us fund railroad crossings. A lot of those are in rural areas. I know that Representative Coram wants to come up here and talk about the small number of miles that he's got, and he can't possibly have all these crossings, but we'll see what he has to say.
Representative Coram.
Thank you, Mr. Assistant Majority Leader. Representative Tyler, in my 6 years here, you have run a lot of bad bills. But this is a very good bill, and I'm very proud to support you on this bill. And, you know, I don't have a lot of rail line in my district. My former district at Delta County, I had a lot of crossings there. One I talked about in committee was we built an overpass. Spent over $15 million building this overpass over the railroad tracks. I commented at the time I didn't think it was a good idea. I thought a crossing would have been sufficient because I was concerned about the mine shutting down. And lo and behold, we spent $15 million on an overpass and 2 mines shut down.
Representative Tyler.
Thank you, Mr. Chair. So, Representative Coram, I might be able to make a deal here. I've got an intersection at 6th and Wadsworth that hasn't been done because it's just been sitting there and it's a real mess. Maybe we could sort of take part of that overpass and move it up to 6th and Wadsworth. You think we could manage that?
Representative Coram.
Thank you, Mr. Assistant Majority Leader. I actually know some people that are in the heavy moving business. We'll see what we can do to get that done to transport that over to you.
Representative Tyler.
Thank you, Mr. Chair. And can we put that on your gooseneck trailer that you're worried about?
Representative Vigil.
Thank you, Mr. Majority Leader. In Walsenburg and other parts of the state, Alamosa, we have a lot of railroad crossings, and they're very noisy. And you know, this is a good bill, and I want all you members to know out there that this is a good bill, and hopefully we can one of these days get a response to all the loud noise. But for right now, this is a good stopgap bill. But thank you so much for supporting this bill and ask for a yes vote.
Representative Neville.
Thank you, Mr. Chair. And members, on the actual bill itself, I do have issues with taking HUTF funds and putting them towards these safety stop areas. Right now, we actually have a significant train going through my district, and there is the safety signals there, and the town is actually looking at making it a quiet zone. Guess what? The town's going to pony up the money. The town or a special district in the area will be funding it, not the state. This bill takes state money and puts it into other areas where if they want the signal in their areas, it should be the local jurisdiction doing it, not the state. I urge a no vote.
Is there further discussion on Senate Bill 87? Seeing none, the question before us is the passage of Senate Bill 87. All those in favor say aye. Aye. Opposed, no. Senate Bill 87 passes. Mr. Kohler, please read the title of Senate Bill 69. Senate Bill 69 by Senator Garcia, also Representative Pabon, concerning measures to provide community-based out-of-hospital medical services in connection with making appropriation. Representative Pabon.
Thank you, Mr. Chair. Mr. Chair, I move Senate Bill 69 and the Finance Committee report.
And the Health Insurance and Environment Committee
And
report,
the Health
please.
Insurance and Environment Committee report as well.
Thank you, Representative Pabon. To the Finance Committee report.
Thank you, Mr. Chair. Mr. Chair, the Finance Committee report was actually very good work done by the Finance Committee. It was an amendment that brought all the stakeholders together. The Department of Public Health and Environment, which I know is important for this side of the aisle, but also the community paramedics, the different regional and local jurisdictions, and it essentially was kumbaya. If you missed it, you missed quite a sight. And but for those of you who are there, you know exactly what I'm talking about. So I ask for an aye vote.
Further discussion on the Finance Committee report. Representative Klingenschmidt.
Thank you, Mr. Chair. I move Amendment L018 to the Finance Committee report and request it to be displayed on the screen.
Amendment L018 to the Finance Committee report has been moved and is displayed to the amendment. Representative Klingenschmidt.
Thank you, Mr. Chair. So the Finance Committee added a otherwise good amendment. There was a lot of agreement, but there were certain groups of firefighters that did not agree to this program. And so they went to negotiate, and some people say there was a negotiation, and they came up with this sunset clause. So my amendment removes the sunset clause for the exemption. If you're a firefighter group who does not want to be under this new law, and you already have a thriving existing program, including the paramedics in Longmont, the paramedics in Colorado Springs. You already have this program, and you want to keep doing the program you have, then my amendment would let you keep doing the program you have. If my amendment fails, then those exemptions will be sunset in 2021. So I don't think they should be sunset. I think the paramedics in Longmont and Colorado Springs, who are doing a great job, already have an existing program which they support. They should not be subject to an exemption, or they should not have their exemption revoked after 5 years automatically. If anything, they ought to be invited back to the table in 5 years. And I appreciate the bill sponsor. I appreciate the long stakeholder process that they had. And yet, some of those stakeholders told me they didn't want this program. And so the Senate did pass a bill, Senate Bill 69, that gave them exemptions. And now, unfortunately, the Finance Committee sunset revokes those exemptions, revokes the Longmont exemption, the Colorado Springs exemption, after 5 years in 2021. So I don't want to sunset that. I think we should take out the sunset and let that exemption stand as those stakeholders requested. I urge a yes vote on L018.
Representative Pabon.
Thank you, Mr. Chair, and Representative Klingenschmidt did have an objection to this amendment in the HIE committee, and so recognize his tenacity for sure. But here's the situation, of course. Like any updated rules and regulations, they evolve and change over time. And while we all wish that we could maintain the status quo for 1 to 5 years under this sunset, which is an unprecedented amount, if I do say so myself, on any change in regulation for an existing program. But this says you've got time to adjust. While everyone else has to adjust on day one, we'll give you 5 years to adjust, change your budgets, assume, make different assumptions. And what this does, it says for all perpetuity, for all time, no matter how good or bad your program is, you get to keep the status quo. That's not good enough for Colorado. That's not good enough for our paramedics and our firefighters, and we should vote no on this amendment.
Representative Klingenschmidt.
Thank you, Mr. Chair. I just don't want anyone to have the mistaken impression that all firefighters support this bill, that all paramedics support this bill, because there were certain stakeholders
including firefighters in Longmont to Colorado Springs, including paramedics in Longmont to Colorado Springs, that opposed this bill. That when they were in the room, when they were being invited as part of the stakeholder process, they said, no, we don't want new regulations. We have our existing program and it works just fine, thank you. So, the Senate passed a bill allowing those exemptions for these firefighters and paramedics who didn't want more government regulations. And the Senate passed it, and everyone was happy with those exemptions for those people who didn't want more regulations. But now, we see the Finance Committee report and how they have amended out those exemptions after 5 years. I think this breaks the deal. This is like a bait and switch. They fooled the Senate into voting yes on more regulations with the premise that some people would be exempt. And now even those people are not exempt. Nobody's going to be exempt. Everybody's going to get bigger government. And some firefighters, some paramedics do not want that. So my amendment would satisfy all parties. I think it's a happy medium. The people who want more regs, they can have them. The people that don't want more regs, they don't have to have them. My amendment makes it reasonable for both sides of the firefighter and paramedic community to be happy with this bill. Otherwise, half of them are going to be unhappy with this bill. I urge a yes vote on the amendment, and if the amendment fails, then I urge a no vote on the bill.
Representative Brown.
Thank you, Mr. Assistant Majority Leader. I did hear this bill in committee and made a few notes, and I was all in favor of the bill, and I thought it was a good bill and thought that I could support it. And then we started talking about the exemption, and that was a good thing, in my opinion. The exemption of firefighters that did not want to be in this under this law could opt out of the law. And when I found out that that was not the case, then I had to change my vote, and I voted against the bill for that very reason. I could be in favor of this bill if we passed this amendment. So I would ask for a yes vote on this amendment. Thank you.
Is there further discussion on Amendment L018? Seeing none, the question before us is the passage of Amendment L018. All those in favor say aye. Aye. Opposed, no? No. Amendment L018 is lost. To the Finance Committee report, is there further discussion? Seeing none, the question before us is the passage of the Finance Committee report. All those in favor say aye.
Aye.
Opposed, no? Finance Committee report is adopted. To the Health Insurance and Environment Committee report, Representative Pabon.
Thank you, Mr. Chair. And Mr. Chair, many of the things that we did in the HIE committee, we actually addressed in the Finance Committee report. And so ask for an aye vote on the HIE committee report.
Is there further discussion on the Health Insurance and Environment Committee report? Seeing none, the question before us is the adoption of the committee report. All those in favor say aye.
Aye.
Opposed, no. The Health Insurance and Environment Committee report is adopted. To the bill, Representative Pabon.
Thank you, Mr. Chair. And members, this bill, Community Paramedicine Regulation, is an important bill for every corner of Colorado. And I have to give a lot of credit to the stakeholders who've worked on this bill tirelessly from the beginning. Had stakeholder meetings starting in 2015, poured over to now, and are still working to make sure this is a very good bill. But one of the most important stakeholders in this, and folks with our titles and our elected positions sometimes don't get recognized, but I do want to recognize a special senator, Senator Leroy Garcia. He really convened this group of stakeholders and was tenacious in his ability to get public safety, to get community safety, to get consumer safety in place for all areas of Colorado. And this bill essentially recognizes that our current system is an emergency system and only allows for treatment by paramedics to transport and take folks to the emergency room. And you all know the high cost of emergency room care. So this turns that model into a more community model, a holistic model. Says that we can have paramedics and firefighters treat folks in their most safe place, and that can many times be their home. Allow them to be treated, follow up on their diabetes, their blood pressure, whatever it may be, and not cause thousands and thousands of dollars of billing and treatment for what otherwise might be a simple issue that can be handled at home. So this is a good bill, saves Coloradoans money, saves consumers the ability to go not to the emergency room but stay in their homes. I ask for an aye vote.
Representative Brown.
Thank you, Mr. Chair. I like this bill. It'll save money as far as health care is concerned. But I'd like to ask the sponsor why it is so important that we take out the opt-out clause. If you can tell me, and I know there was testimony in committee from some of the districts that they demanded that this opt-out, this exemption be done away with. But I can't understand, this is such a good bill, and I can't understand why it is so important to take that exemption away. Maybe you could answer that question for me. Thank you.
Representative Pabon.
Thank you, Mr. Chair. And just to clarify, we didn't take the exemption away. We sunsetted the exemption after 5 years. So that's a big difference, because if you take the exemption out completely, then it says on day one, you've got to change your rules, you got to change your regulations, you got to put this regulatory system into place. And rather than do that, we said to those communities, and again, there are a minority number of communities who've already endeavored towards this area, and we got to give them credit for doing that. But we said, you got 5 years to adjust. And again, if you're an engineer or you're a nurse or you're a doctor or a lawyer, the standards around your own profession are changing and evolving. And it's difficult to say, well, for those engineers who live in, say, Representative Sias's district, you're exempt from these new regulations. Because, well, you've asked for that exemption, you set these things up, you work towards that goal, but everyone else who has to update their credentials, update their training, update their service, this is a community safety issue. It's a consumer safety issue. And so we want eventually everyone to be caught up to the same standard, to the same levels. And my guess is these communities that are exempted will already be at that level, if not above. And so we won't even have to worry about them getting caught up. So that's why we did it. And, what's good for Huerfano County, what's good for Yuma County should be good for everyone else. And that's why we're asking for an aye vote.
Representative Brown.
Thank you, Mr. Chair. And I think, the 5 years helps, but this is adding responsibility to every district, every fire district in the state. And if they do not want to have this responsibility, I think that they should be able to opt out of that. It's a matter of cost, and it depends on the district that you're looking at. And I still don't understand why it has to be mandatory that these districts do this when possibly it is absolutely not needed that they do it. And it will increase costs to these districts. We've seen a huge cost in my area in the districts anyway, and this may be an excuse to raise taxes. I don't know. Anyway, guess I'm not going to get an answer.
Further discussion on Senate Bill 69. Seeing none, the question before us is the passage of Senate Bill 69. All those in favor say aye. Aye. Opposed, no. Senate Bill 69 passes. Mr. Kohler, please read the title of the Senate Bill 161.
Senate Bill 161 by Senator Crowder, also Representative Primavera, concerning the regulation of athletic trainers about division of professions and occupations in the Department of Regulatory Agencies in connection with making appropriation.
Representative Primavera.
Thank you, Mr. Chair. I move Senate Bill 161, and I don't believe there's any committee reports.
To the bill, Representative Primavera.
Thank you, Mr. Chair. Athletic trainers are highly skilled, well-trained healthcare professionals and first responders. When an injury on the playing field occurs, like a cardiac arrest, a concussion, heat stroke, or other injuries, athletic trainers are immediately at the side of the injured player. They quickly evaluate the injury, stabilize the player, and get the injured player to an appropriate medical specialist. And then after treatment, they oversee the player's rehabilitation and return to play. 49 states regulate athletic trainers, and they work in various settings, including secondary schools and colleges and universities. A large percentage of athletic trainers work with physicians in clinics and hospitals. 23 organizations support this bill, including the Denver Broncos, which I know Representative Perbone is interested in, the University of Colorado, 14 statewide medical organizations, and numerous sports clubs. We also have 471 individuals signed on to a letter of support, including 132 physicians and 186 coaches. Healthcare money is saved by these professionals, especially in secondary schools. One metro area school estimated their family's healthcare savings due to the care prevented or provided by athletic trainers was under $900. The regulation of athletic trainers is funded by the athletic trainers' fees and is a director model with no board. So this bill does several things. It adds title protections for the abbreviation Athletic Trainers Certified. It requires evidence of current national certification at registration, and if required by the director at renewal. And it adds grounds for discipline or failure for the use of an athletic trainer to say they're an athletic trainer if they aren't registered. It repeals September 2026, and although John Elway didn't come and testify in committee, I still ask for an aye vote.
Is there further discussion on Senate Bill 161? Seeing none, the question before us is the passage of Senate Bill 161. All those in favor say aye.
Aye.
Opposed, no. Senate Bill 161 passes. Mr. Kohler, please read the title of the Senate Bill 163.
Senate Bill 163 by Senator Johnston, also Representative Kagan, concerning a study of an organizational recodification of Title 12 of the Colorado Revised Statutes governing the regulation of professions and occupations in connection with making appropriation.
Representative Kagan.
Mr. Chair, I move Senate Bill 163 and the Appropriations Committee report.
Representative Kagan, no Appropriations Committee report to the bill.
Oh. Mr. Chair, I move Senate Bill 163.
To the bill, Representative Kagan.
Senate Bill 163 comes from the Legislative Legal Services Committee, from which it was voted out unanimously. It lays down the parameters for the Office of Legislative Legal Services to study the feasibility of reorganizing the Title 12 statutes, which are currently 1,500 pages long, tediously repetitive, extremely difficult for lawyers to use, judges to navigate, regulated professions to understand. Bits of statute regulating the same profession are dotted around. They are rewritten word for word instead of referred to in other places. It is long, it is wieldy, it is cumbersome, and the Office of Legislative Legal Services has undertaken, if we pass this bill, to streamline and harmonize and do the work necessary to make that Title 12 more efficient, elegant, and effective. I urge an aye vote.
Is there any further discussion on Senate Bill 163? Seeing none, the question before us is the passage of Senate Bill 163. All those in favor say aye. Opposed, no. Senate Bill 163 passes. Mr. Kohler, please read the title of Senate Bill 180.
Senate Bill 180 by Senators Woods and John, also Representatives Kagan and Ransom, concerning a specialized program within the Department of Corrections for certain offenders who were convicted as adults for offenses they committed as juveniles in connection with making appropriations.
Yes. How about if
Thank you, Mr. Kohler. Representative Ransom.
Thank you, Madam Chair. I move Senate Bill 180 and the Judiciary Report.
Thank you, Representative Ransom. To the Judiciary Committee report.
The Judiciary Committee added an amendment saying that someone convicted of murder but not felony murder must serve 27 years of their sentence before becoming eligible for the program with the DOC. I urge and I vote.
Is there any further discussion on the Judiciary Committee report? Representative Willett.
Thank you, Madam Chair. I have an amendment to the committee report, and I would ask that I move that L022 be displayed.
So you move Amendment L022, Representative Willett?
Yes, as an amendment to the committee report.
Amendment L022 has been moved and is properly displayed. Please explain the amendment, Representative Willett.
Thank you, Madam Chair. During the Judiciary Committee, we had two amendments, 17 and 18. Rep. Foote ran 17, Rep. Willett ran 18. 18, they were both passed, but it turned out our drafter found that 18 was put in an awkward place. It was called clunky in order, so to speak. So all that 022 does is take the original number 18 amendment by Willett and moves it to a different place at the bottom of what was Rep. Foote's amendment, and I understand perhaps the sponsors may view this not substantively or content, but procedurally and structurally as being okay to just move the location of the amendment.
Representative Kagan.
Madam Chair, members of the committee, I oppose the policy that is embedded in Amendment 22. I do not think it is well advised, and I oppose the policy. However, the amendment itself is not substantive. It simply puts it in better place. And so for that reason, I don't oppose the amendment, although I want to make this absolutely clear. I and many members of the Senate and many members of this House, I think, oppose the policy of excluding 17-year-olds from consideration for the special program. But this amendment simply moves it from one place to another. That is an improvement in the structure of the bill, and so I don't oppose this amendment, although I do oppose the underlying policy choice that has been made.
Representative Foote.
Thank you, Madam Chair. I hope that we'll support this amendment. It doesn't really do anything to the policy that's in the committee report. It basically, here's what happened. We were in Judiciary, as you all know, until very early in the morning on Friday. We dealt with these amendments at about 1:30 in the morning, maybe 2 o'clock in the morning. I don't know about you, but something that may look good about 1:30 in the morning, when you get a little sleep, you may realize it didn't exactly flow the way you thought it did. And that's exactly what this is about. It's about taking another look at the language and then saying, okay, well, it makes more sense actually to do it this particular way as opposed to the way that it was actually done in committee. It just makes clear what the policy is. I'm assuming that we'll have a policy debate at some other point in time, and we can go there, and I'm happy to, because I think it's personally good policy, and as did the majority of the Judiciary Committee. But this particular amendment just makes it so that it's more readable. Should the policy stay on the bill as passed through both houses and signed by the governor, it's actually something that's readable and people will understand if they read it.
Representative Garnett. Is there any further discussion on Amendment L022? Seeing none, the question, Representative Fields.
Thank you, Madam Chair, and I rise in support of this amendment. I think it strikes the right balance. Vote yes.
Is there any further discussion on Amendment L022? Seeing none, the question before us is the passage of Amendment L022. All those in favor say aye. Aye. Opposed, no? No. Amendment L022 passes. To the bill, Representative Kagan. I'm sorry, we're back to the Judiciary Committee report. Is there any further discussion on the Judiciary Committee report? Seeing none, the question before us is the passage of the Judiciary Committee report. All those in favor say aye.
Well, sorry.
Representative Kagan.
Madam Chair, I think it behooves me to say that although I don't oppose the Judiciary Committee report, there is another policy in this Judiciary Committee report which I think will come up later as the bill moves through the process, which I also oppose and which many members of this House also oppose and which the Senate very overwhelmingly opposes, and that is the embodiment in this Judiciary Committee report of a proposal that eligibility for the special program will not be available until 27 years into a prisoner's sentence instead of after 20 years, and that it will not be possible to complete the program until after 30 years in the Department of Corrections, whereas the original unreported version of the bill and the Senate version of the bill said you can graduate after 25 years. That policy is in this Judiciary Committee report. That policy, like the policy of banning 17-year-olds, is a policy that Representative Ransom and I both oppose, that many members of this House will oppose, I think, when the specific issue comes up, and that the Senate opposes. But, however, that argument is not necessarily for today, and so I do not oppose the Judiciary Committee report.
Representative Garnett.
Thank you, Madam Chair. And I also oppose much of the language that's in the Judiciary Committee report, but I'm not going to say oppose the Judiciary Committee report because I respect the chair of the Judiciary Committee and I respect the work that he's put into this bill, and I hope that we can get to a place where we can vote on a compromise that doesn't include some of the language that I believe is much harsher than anything the Colorado legislature should be supporting. So with that, I just want to make sure the record reflected that my sentiment is against the policy, but I'm not going to oppose the Judiciary Committee report because of the respect I have for the Judiciary Chair.
Representative Foote.
Thank you, Madam Chair. A couple things since it was brought up, and I think it's a good time to talk about this, and it may be a preview of things to come. But, you know, you all know that there's two houses here in this legislature, and it's for a good reason. When this bill came over from the Senate, basically the word was no changes, no amendments. That was the word from the folks that were really supporting this on the Senate side. In other words, don't do your job. Trust the version as it came out of the Senate. It's fine. Don't worry about it. You know, take a look at it, of course, and maybe have your discussion, but at the end of the day, don't really worry about amending it. Don't worry about checking it. Don't worry about making sure that it's actually good policy. And to me, I think that's not doing our job. I think we have the responsibility, and I'll tell you what, there was another bill that came over from the Senate, 35-0, that came in front of Judiciary that very night. But oh, let me tell you what happened with that bill. That was a disaster. And so, let me, and so, all I'm saying here, and this is not talking about any specific sponsor, and I don't want anyone to think that, because it had nothing to do with the sponsor. But there are bills that come over that we need to take a look at. And I'll tell you, and I'll concede, every once in a while it may happen as well from us to the Senate, where we need to take a look at these things from both houses and see if it's good policy. And what's good policy in this case, I think this bill actually is good policy, but I think it needed some tweaking, and that's exactly what the amendment was all about, was to tweak the bill so there was good policy. We heard in Judiciary Committee a lot, probably 95% of the times, about the juveniles that were found guilty of crimes like first-degree murder. And we heard a lot about how they should be rehabilitated, and I agree with that. We heard a lot about considerations for the juveniles. We heard hardly anything about consideration of the victims' families. And I think that's out of balance. I think that's out of balance. We need to consider all of it. We need to consider the juvenile rehabilitation. We also need to consider victims and their families. And what we heard is that when we combine the Senate Bill 181 and Senate Bill 180, and we've heard about that already, and the amount of time that juveniles will be serving before they're eligible for parole, there was an imbalance between the two bills. There was an imbalance where the goalpost had been moved from one bill to the next, and that's exactly what victims' families have told us through email and also through the small amount of testimony that occurred in the Judiciary Committee for this. We are moving the goalposts again on the victims' families, and we need to consider that. I'm not saying that we should give 100% consideration to the punishment aspect or to the victims' families, but we should consider it. And that's exactly what the amendment that I proposed and the majority of the Judiciary Committee thought was appropriate does. It gives due consideration to those aspects. Criminal justice is about rehabilitation. That's one of the parts about it. It's also about restitution. It's about deterrence, and it's about punishment. And we should not give short shrift to any one of those. We should make sure that we acknowledge all of those. And the amendment itself actually is a pretty reasonable and small and narrow amendment that actually, as it turned out in the committee, we heard testimony that would affect very few inmates, and only those that were convicted of first-degree murder, and only delaying the amount of time before they can apply for, get accepted, and then complete the program. That's it. And so that's why I proposed the amendment, and I believe that's why the majority of the Judiciary Committee agreed with the amendment, and that's why when the time comes, I'll be asking that the majority of the House support the amendment as well.
Representative Salazar.
Thank you, Madam Chair. And I did not support the amendment. I think the amendment was a meddling by stakeholders of a really good bill that came over from the Senate that was supported by vast majority of Democrats and Republicans over there. It was a way of trying to leave one's mark on a bill that should not have been marked, and doing it in such a way that it's ludicrous. And I'll tell you why. Because what that amendment said is that essentially 17-year-olds are so much different than 16-year-olds. 17-year-olds are so much different than 15-year-olds. 17-year-olds are so much different than someone who's 16 years and 10 months. When the testimony from witnesses came up and said that 17-year-olds and their thought process are no different. And as a matter of fact, the growth of the human brain, as experts indicated, it takes about 25 years before the full growth is realized. So this amendment was just a way of marking up a good bill. There is no basis in fact, both scientific or otherwise. It was just a way of marking up a good bill. And those who offered the amendment were unable to say what the difference is between a 17-year-old and a 16-year-old. That's why I opposed this amendment. If it had some basis in fact, then that's one thing. But it was not. It was meddlesome by stakeholders to want to step into this bill, a good bill, coming out of the Senate bipartisanly, and just trying to meddle with it. But I will support the Chair of Judiciary's opinion on this, that we should not oppose this Judiciary Committee report, and we should move forward with it. But let's not anybody be fooled by why this amendment was offered.
Representative Melton.
Thank you, Madam Chair. And I just also want to rise and say that although there are a lot of things in this committee report that I disagree with, I'm going to be a yes on the committee report today. But I want it to be clear, one, that yes, there was another bill that was run by an extraordinary sponsor in Judiciary that passed the Senate 35-0 and unfortunately did not make it. We had a late evening that night and we did vet all these bills thoroughly. But when it came to this amendment and the amendments that were added on around the 17-year-olds and around the classes that would be eligible, I don't feel like we ever really came to a strong conversation around that age and around why this class of convicts or people who have been convicted under this class that were being excluded, why they should be excluded from rehabilitation. And so I was a no on these amendments, and I'm sad to see them as a part of this committee report, but I understand that there are other things in the committee report that needs to get passed. And so with that, members, I would say vote yes on this with reservation.
Thank you, Representative Melton. Representative Sane.
Thank you, Madam Chair. Members, I urge a yes vote on this committee report, and I'll tell you why. These amendments that we're adding in judiciary are asking for only a modicum of consideration for victims' families. It's asking for a modicum of common sense. We're talking about the worst of the worst, first-degree murder, premeditated murder. This is a very narrow slice, but we should have some consideration for these families. Some people, and that's including juveniles, maybe shouldn't be let out at all, depending on the circumstances and if they can be rehabilitated. So it's asking for some discretion here, and I think that these amendments toe that fine line, and I would urge a yes support on this committee report.
Thank you, Representative Sane. Representative Rosenthal.
Thank you, Madam Chair. And I was not in the committee at the time, but you know, from reading the bill and speaking with members and listening to this conversation, I have to say that I do not support this committee report. And the reason why is because the two of the major issues that were brought up, one being the difference between the 15 or 16 or 17-year-old, so excluding the 17-year-olds, seriously, in the development of children, oftentimes a 17-year-old will have a lower development than a 15-year-old. So sometimes when you have that kind of difference, it becomes arbitrary sometimes to have that kind of age difference. Secondly, when discussing this bill, you know, I think if you look at the Senate version, and I support the Senate version as it came out of the Senate, it was carefully crafted. It had a lot of to and fro and negotiation. And I'm not saying that we shouldn't do our job. That's what I'm not saying. But I'm saying let's give it more respect than I think what's happening right now. I think we need to make sure that we look at that compromise and see it as what it is, which is very carefully crafted, and that if we mess with it too much, then it might unravel the bill. And so therefore, I do not support this committee report.
Thank you, Representative Rosenthal. Representative Willett.
Thank you, Madam Chair. Members, if I could give us a little recheck and resetting of what this is all about. I think we're getting lost in the weeds a little. This is a special program. This has nothing to do with the case law or the constitutional proclamations. That came through the Senate Bill 181 you've already heard about. This is about a special program. It says special program in the bill. So the question is, how many heinous murderers do you want to give a special program to, the benefits of a special program? So to say that people are offended by reaching out to the victims' families and trying to better define who gets the special program, I think is hardly something that is illogical or without any basis. Now, I am a co-sponsor of this bill because I do believe in restorative justice, but I believe it should be for those who've earned it and for those who deserve a special program. They already have constitutional protections. 181 will take care of that. In fact, the truth is we don't even need 181 because the courts can do that themselves without 181, and there are legal problems with 181. So as we looked at 180, who should be able to get into this special program? One problem, as you've heard from Representative Foote, is by letting them get in at 20 years served instead of 27, that would be inconsistent with 181 and with our early parole rules. So that makes a lot of sense. It dovetails the two. Both Representative Foote and my amendments only go to the worst offenders. Now, there had been some good arguments and a lot of heartburn. Shouldn't we remove all murderers from this special program? That's where we could have started. Then it was, well, if you're not going to remove all murderers, at least remove first-degree murderers totally from the program. That wasn't done. So heinous murderers are still available for this program. So now you say, well, where do we start drawing some lines? Contrary to what I've heard, there are times in the law we look at different ages and different maturities. We allow people to drive at 15 and a half with a permit. We allow people to drive at 16. We allow people to vote at 18. We allow people to babysit at certain ages. We allow people to have sex at certain ages, and we define those ages. Sure, it's not a perfect science, but we say there's a difference between a 12-year-old, a 13-year-old, a 15-and-a-half-year-old, a 16-year-old, and an 18-year-old. Now, under their logic, if the brain doesn't fully mature until 25, and I've even heard 35, for goodness sakes. Well, I happen to have raised 4 children like some of you have. I happen to have been around a lot of children. And there are differences between 14 and 15-year-olds and 17-year-olds and 8 months. What we're talking about here, when they criticize my amendment to take out those who are 17 to 18-year-old, you are almost an adult. You realize if you commit a heinous murder at 17 years old in 364 days, you can get in this program, but one day later it's not even available at all. You're an adult. So where do you draw that line? Well, the reason I came up with this is when I look at the newspapers and the most heinous acts, Austin Sigg, Verl Mangum, the guy that just killed Sheriff Geer, over and over, 17-year-old, 10 months, 17-year-old, 8 months. These guys typically, some women, but these guys are at the point where they can just about fight for their country, they can just about vote. So if we're going to have a special program, why in the world wouldn't we put some limits on a special program? That is the definition of special. It's not for everyone. If we are going to be letting people out sooner than the Constitution requires us, why don't we put some tighter requirements on the program? Furthermore, the Senate, they say, well, you're just earmarking some unnecessary exceptions. The Senate put on sex offense and mental health. They don't let them be available for the program. So there's obviously an attempt to say we want this to be for our best applicants. Not only, and the bill says, read the bill, they look at the age, they look at how closely they were associated with the crime, they look at how heinous the crime was. So this is already in it. The bill calls for the governor and the parole board to look at the age. Why, as the elected officials in the world, wouldn't we look at age? Folks, I'm a yes with these 2 amendments, and I was a co-sponsor originally because of the concept, restorative justice. Without some recognition that we need to be answerable to the victims and their families of guys like Mangum, who was raping a tiny young girl, and the mother walked in, he proceeded to kill the young girl and the mother at 17 and 10 months or whatever his age was. I'm sorry. He's still, the last point I'll make, folks, don't forget, if he reaches some spectacular redemption in life, he can apply for clemency and early parole. We're not taking anything away from those. The most heinous offenders still have that. All we're saying, if someone acts like we're being unheartful or unthinking or illogical, all we're saying is they shouldn't get the benefit of this special program. Members, keep these amendments on. It's the right policy. As Rep. Foote said, we've done our job here. We've looked at this hard and not be bent by the special interests. It's just good logic. Thank you.
Representative Lebsack.
Thank you, Madam Chair. And members, a juvenile is a juvenile, whether that person is 17 or 16 years old, and so I'm opposed to the policy. I was opposed to both amendments that passed. The judiciary, I do not serve on judiciary, and the only reason why I'm going to be a yes on this committee report is because I'm hopeful that a conference committee will strip this out of the bill. The Senate bill was much better, was much stronger, and that's my hope, is that we we eventually pass the Senate version of this bill.
Representative Foote.
Thank you, Madam Chair. I don't want to repeat too much of what Representative Willett said because I think it was very well said. I just wanted to make a couple of things clear because I think there might be some confusion about the amendments here. There were 2 amendments put on during committee. Representative Willett got an amendment on that dealt with the age range, so 17 years old would be ineligible if they're only convicted of first-degree murder. And then my amendment just increased the amount of years that the juvenile, before the juvenile that's convicted of only first-degree murder, not felony murder, but first-degree murder, can actually apply for the program from 20 to 27. And I heard up here that what these amendments were is they came up with arbitrary numbers. Well, yeah, I mean, everything in this was arbitrary. 20 years is arbitrary, 25 years is arbitrary. It's all arbitrary. It's really depending on what people think is best. And that's our job as policymakers, is to listen to our conscience, listen to our constituents, and decide what we think is best, what fulfills our constituents' wishes, and most importantly, our conscience, our wishes of our conscience. And I heard up here that these amendments were merely just meddling with the stakeholders' work. Like, we don't really have a role in this. Maybe it's more like, let's let these stakeholders that are not elected and not answerable to their constituents get together and come up with something, present it to the electeds in the Senate and the House, and just make sure they write off on it and say, okay, and just be done with it. Well, that's not the way that we should work. I know that's not the way that I work. And that's why, in my amendment in particular, and by the way, I do want to be clear that these amendments were our amendments. They weren't brought to us by a particular stakeholder or a particular group, but we came up with them on our own. And I know that's why I came up with the one that I did after seeing the bill and making sure that it fit in with what I thought my constituents would want and what my conscience would demand. That's why I ended up offering this, not to meddle with stakeholders' work. I think that the proponents of the bill that got together and came up with the bill did fine work, and they certainly have a policy position that they advocate for, and I respect that. It doesn't mean, though, that we're predestined as legislators to have to agree with it just because they came up with it. That's why we all have the ability to offer amendments on any bill, and that's why many of us do. And I hope that the majority of the House, when the time comes, will vote to make sure that these amendments stay on.
Representative Carver. Oh, Representative Willett.
Thank you, Madam Chair. A couple of clarifications. As Rep. Foote said, and I want to confirm this because I see some snickering that I don't deem appropriate. He and I filled in on Finance Committee one day. He and I went out in the hall from Finance and came up with these 2 amendments on our own. So any indication that this is some sort of arm twisting is just unfair. Second of all, one thing that you need to be very clear on, both Rep. Foote's amendment and my amendment don't apply to what's called felony murder. So the classic example is the kid that's in the back seat, gangbanging situation, or that somebody robs a liquor store, driving away from the liquor store, runs over somebody and kills somebody, and the person in the back seat can be convicted of murder. That's called felony murder. My amendment doesn't apply to that. So if you're between 17 and 18, you can still get this special program for that. Likewise, Rep. Foote's amendment that doesn't kick in until you're 27 doesn't apply to that felony murder. So we really have worked so hard to hit the sweet spot of just the most heinous murders, the oldest juveniles possible, and the worst crimes, to not let them have a special program. They still have all their other rights under 181, all their constitutional rights, clemency, early parole, and everything else. So be clear on that. Thank you.
Representative Carver.
Thank you, Madam Chair. I rise in strong support of this committee report and the amendments. And it was really important to have these amendments because otherwise it did not mesh well with what ultimately was decided in 181. The amendment that deals with the 17-year-old and first-degree murder, that is the principle. And folks, 18 if you want to get right down to it, is an arbitrary number. What we're talking about is an individual, at least 17 years of age, who was the principal in a first-degree murder. The shooter, the person who did the knife, the person who did the torture murder. And the Senate excluded from this special program, and remember, this program applies to all juveniles convicted of all felonies, and they're eligible for this special program after 20 years. And when they go into this special program, which is a 3-year program, it then increases hugely their chances for early parole. And what some of us believed is that those juveniles who were 17, who committed first-degree murder as a principal, and I've got 4 of these cases, horrific torture murder cases in El Paso County, that those folks should be excluded from this program, just like the Senate excluded sexual offenders. If somebody was a juvenile who was convicted of rape, they're not eligible for this program. So if you're convicted of sexual offenses, you're not eligible for the program. If you have serious mental illness, you're not eligible for the program. This amendment simply says if you committed first-degree murder and were 17 and were a principal, you're not eligible for this program. That's all the amendment does. And the other amendment, again, I think when we get to the bill, simply is trying to match up 181, which reduced parole date to 40 years with earned time down to 30, and not to have results that were going to conflict. Again, for what offender? First-degree murder for a principal who shot, who actively killed the person. Whereas felony murder is like the accessory, the person driving the getaway car. So I support the committee report. I support these amendments. While I personally in committee would have liked to have excluded all juveniles convicted of first-degree murder as principal, I believe that this is the better way to go, and so I would urge your support of the committee report and ultimately the bill with the amendments.
Is there any further discussion on the Judiciary Committee report? Representative Sane.
Thank you, Madam Chair. And members, I just want to reiterate something real quick. We're talking about the worst of the worst here. We're talking about torture, murder, premeditated murder. We shouldn't coddle the worst of the worst. And this is what these amendments do. They actually make a very narrow path so we can make sure that those folks aren't let out early, that the victims' families aren't caught by surprise, and we're lining it up with the other bill. I think that makes a lot of common sense, and that's all we're asking for is just a little bit of common sense. I'd urge a yes vote on the committee report.
Representative Kagan.
Madam Chair, I urge an aye vote on the Judiciary Committee report.
Is there any further discussion on the Judiciary Committee report? Seeing none, a division has been called. All those in the chamber not entitled to vote, please be seated.
Lori, it's going to.
What's the division on?
She can withdraw it. Hold on a second. She can withdraw it. It's up to her.
Well, she'll have to withdraw it. Hey, Lori?
Okay, all those in the chamber not entitled to vote, please be seated. All those in favor of the Judiciary Committee report, please stand and remain standing in one place until the count is taken. You may be seated. The chair is not in doubt. The Judiciary Committee report is passed. Representative Kagan, to the bill.
Thank you, Madam Chair. I urge an aye vote on this bill. Let me tell you what this bill does. Right now, this bill deals with applications to the governor's office for clemency in the form of a pardon, early parole, commutation of sentence. Every juvenile, every adult, every inmate, every criminal in Colorado has the right at any time to petition the governor for clemency. Every juvenile, every adult, at all times has the right to petition the governor for clemency, and the governor has an open, unfettered discretion as to how he or she deals with that application. What this bill does is it gives an opportunity for some selected inmates to say, may I, before I make my petition for clemency, may I have the opportunity to show that I am a worthy applicant? Right now, how does the governor decide who gets clemency? I'll tell you how now governors decide who gets clemency. It depends if you have a celebrity pushing your case. It depends whether you have a spot on the 9 o'clock news making your case famous. It depends whether you have a celebrity lawyer from California, usually, advocating for your clemency petition. That's how the governor now decides, based on public relations. What this bill says is, let's give the governor, whoever he or she may be, let's give the governor something better than a celebrity endorsement, if they can get it, or a spot on the evening news to help them decide. Let's let the Department of Corrections, when they've had 20 years, or now with the amendment, 27 years, to get to know the defendant day in, day out. And then 5 years after that to say, okay, we in the Department of Corrections are going to give you a little more responsibility, a little more freedom, a little more education. We're going to give you work. We're going to give you the opportunity to show that you are what we think you are because we accepted you into the program. And then at the end of that program, when you write your petition for clemency to the governor, you'll be able to put the fact that we recommended you for the program into your petition. You'll be able to put the fact that you did 20 years and were selected by the department for this program into your petition, and you'll be able to put the fact that you have successfully completed the program into your petition. But of course, the petition may be to no avail. That's all up to the governor of the state of Colorado, because that's what the Constitution demands. Now, this bill asks you a fundamental question. Do you want governors considering petitions for clemency to only have what they get from the public relations efforts of the inmate? Or do you want them to have some additional information as to whether or not the Department of Corrections has found them to be worthy of serious consideration? We're giving the best of the worst. We're giving the most reformed of the worst. We're giving the most rehabilitated of the worst the opportunity to show that they are so when they petition the governor for clemency. That makes the clemency process better informed, better considered, and more just. It is not giving a free pass. It is not giving a guarantee. It is not giving a guarantee even of a hearing. It is giving something to put in your petition for clemency to the governor that you can say, I have demonstrated to the Department of Corrections satisfaction that you should give me serious consideration. That is why I urge an aye vote on this bill. It is an advance. And there's one other thing I have to tell you, members, and that is this. When states across the country have considered how to deal with the vexing problem of excessive use of administrative segregation while keeping our prisons and our population safe, Colorado led the way. And now states all across the country come to Colorado to see how we did it here in Colorado. Because they know we're not lenient. They know we're not soft. But they know that we've massively decreased our administrative segregation population in a way that seems to them miraculous, but to us is because we know what we're doing in Colorado. And now, states across the country are vexed by how do we make our clemency process, which everybody agrees should exist. It's in every state's constitution that it exists, that every inmate has the right to apply for clemency. How do we make that work? They will turn to Colorado again if you pass this bill. Once again, we will lead the way in showing how you can do it in a way that does not compromise public safety, that does not compromise but enhances the governor's decision-making process, that really weeds out the most worthy of the inmates who have done the worst things in their youth. Colorado can lead the way on this, as Colorado led the way on administrative segregation, solitary confinement. I urge an aye vote, and thank you.
Representative Ransom.
Thank you, Madam Chair. This bill is not for everybody that's in prison right now. Criminals need to be kept off the streets, as we all know. This bill has to do with we need a deterrence. We need rehabilitation. We need justice. This is a justice system we're talking about. But we also need to be concerned with public safety, and criminals do need to pay the penalties for the crimes they commit. This bill does offer the program that you just heard described by Representative Kagan, and it's not just a get out of jail free card. The men that apply for this are ones that may have found redemption, may have sought forgiveness, and maybe just have grown up. We've all heard about research that people have brains that are still developing until they're in their mid-20s. This bill offers a path for release. It is not just flinging open the doors. It's a long path with several checkpoints that may allow those redeemed men a possible path, if they are proved by the warden and other administrators in the system, and then approved for clemency. It is a long path with many checkpoints that everybody has to complete and pass every single checkpoint before they're eligible for release through this program. And there are many steps during the years where they will become ready. They're grown men by the time they get there. The Senate passes 30-5 on a bipartisan vote, and I urge an aye vote on the bill.
Thank you, Representatives Kagan and Ransom. Is there any further discussion on Senate Bill 180? Seeing none, the question before us is the passage of Senate Bill 180. All those in favor say aye. Aye. Opposed, no. Senate Bill 180 passes. Mr. Kohler, please read the title of Senate Bill 196.
Senate Bill 196 by Senators Cook and Cadman, also Representatives Landgraf and Young, concerning the creation of a pilot program for inclusive higher education for persons with intellectual and developmental disabilities in connection with making an appropriation.
Sure. Representative Young.
Thank you, Madam Chair. I move Senate Bill 196. There are no committee reports.
To the bill, Representative Young.
Thank you, Madam Chair. Well, members, we heard this actually in appropriations earlier this morning as committee of reference, and had a great group of people come and testify. What this bill does is it actually creates pilot projects at 2 universities and 1 community college to allow those with intellectual and developmental disabilities a pathway to post-secondary education. And what we heard today in testimony is that often students finish their K-12 experience and end up with no options as far as what they can do within the state of Colorado. They either sit idly without any opportunity, or they're in a day program that really does not match their needs and their goals, or worst case scenario, if they really do pursue a post-secondary experience, they end up having to go out of state, sometimes hundreds if not thousands of miles, and pay out-of-state tuition for their post-secondary experience. And so this bill actually does what other states, many other states, I believe 47 other states, are already doing in 250 colleges and universities across the country, is providing that pathway for Colorado students to get that Colorado experience, post-secondary Colorado experience at 3 locations. One would be the University of Northern Colorado in Greeley, the other would be the University of Colorado, Colorado Springs, and the third would be Arapahoe Community College. And so it brings also 4 critical stakeholder groups together: the Department of Higher Education, the 3 pilot institutions, which I just mentioned, JFK Partners, which is Colorado's University Center of Excellence for Developmental Disabilities, and the Colorado Initiative for Inclusive Post-Secondary Education. These key groups will work in collaboration to assure the successful launch of these pilot projects. There's some minimum requirements that each inclusive higher education pilot program must meet, and they will integrate students socially and academically so that they really understand what the college and post-secondary experience is. I want to turn this over to my colleague and thank her, Representative Landgraf, for working with me on this bill.
Representative Landgraf.
Thank you, Madam Chair. Some of the benefits to Colorado: students with intellectual disabilities become involved and contributing members of society. Gains in independence lessen the depth of daily supports needed. College campuses are enriched by the added diversity of the student body. Families are able to participate more fully in their community as their students become more independent. Professors acquire new teaching techniques benefiting all students in the class. Barriers are broken as students learn and appreciate differences in a normative manner. Future teachers, social workers, business leaders, therapists gain better insight through practicum experiences, and employers have access to a new pool of capable employees. But what we're really doing, members, is giving a new group of exceptional scholars a pathway to go to college, get an education, become a fuller part of society. This bill is completely funded by the IDD Services Cash Fund, and I would ask for a yes vote.
Is there any further discussion on Senate Bill 196? Seeing none, the question before us is the passage of Senate Bill 196. All those in favor say aye.
Aye.
Opposed, no. Senate Bill 196 passes. Mr. Corey, or Mr. Kohler, please, whatever your name is, please read the title of Senate Bill 199.
Senate Bill 199 by Senator Scott and Stedman, also Representatives Del Grosso and Janal, concerning programs of all-inclusive care for the elderly in connection with determining the capitated rate for services and creating an ombudsman for participants in programs of all-inclusive care for the elderly and making an appropriation.
Mr. Minority Leader.
Thank you, Madam Chair. I move Senate Bill 199, the Health Insurance and Environment Report, and the Appropriations Committee report.
For the Appropriations Committee report.
Thank you, Madam Chair. Members, I move that I urge a no vote on the Appropriations Committee report. This bill is cash funded, says general fund, but basically it's taking money from a cash fund, it's putting into the general fund, and then basically it's a pass-through. But if you look at the original bill, when it passed out of the Senate, it was $225,000. There was an error, I believe, with this Appropriations Committee report, and so I urge a no vote on the Appropriations Committee report.
Is there any further discussion on the Appropriations Committee?
I believe the Joint Budget Committee is okay with this action as well.
Representative Young.
Thank you, Madam Chair, and I urge the no vote on the Appropriations Committee report as well. Thank you.
Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriation Committee report. All those in favor say aye.
Aye.
Opposed, no.
No.
The Appropriations Committee report is lost. Representative Janal.
I'll take this one too.
Mr. Minority Leader.
Thank you, Madam Chair. We are to the Health Insurance and Environment Committee report. I move L015 and ask that it be displayed unless my co-sponsor has a objection.
Amendment L015 to the Health Insurance and Environment Committee report has been moved and is properly displayed. Mr. Minority Leader.
Thank you, Madam Chair. In committee, there was an amendment that got put on that basically had some clarifying language, but one of the clarifying amendments that was put on, or one piece of that, moved this program from DHS to HCPF, and it should have actually stayed with DHS. So this is basically undoing a clarification on the clarification amendment. So I urge an aye vote on L015.
Is there any further discussion on Amendment L015? Seeing none, the question before us is the passage of Amendment L015. All those in favor say aye.
Aye.
Opposed, no. Amendment L015 passes.
To the bill.
Representative Janal.
Thank you, Madam Chair. To the bill?
Yes. No, we're still on the committee report.
Oh, I'm sorry. I screwed that one up. So after we've got that amendment on there, I urge an aye vote on the HIE committee report.
Is there any further discussion on the Health Insurance and Environment Committee report? Seeing none, the question before us is the adoption of the Health Insurance and Environment Committee report. All those in favor say aye.
Aye.
Opposed, no. The committee report is adopted. To the bill. Representative Janal.
Thank you, Madam Chair. Senate Bill 199 creates an ombudsman program that's specific for the PACE program. It also requires HCPF to establish an upper payment limit that is adjusted to individuals in regards to data such as frailty, functionality, medical diagnoses, cost, utilization, and it assesses the true costs of the PACE client to the state of Colorado. It also makes sure that HCPF does the study and holds the pay rate constant until the upper limit has been established. I ask for an aye vote.
Mr. Minority Leader.
Thank you, Madam Chair and members. There is an ombudsman, but it is paid for by the gifts, grants, and donations, and there is also a study that's paid for by gifts, grants, and donations. And so it doesn't cost the state money for either one of those, and so I urge an aye vote on Senate Bill 199.
Is there any further discussion on Senate Bill 199? Seeing none, the question before us is the passage of Senate Bill 199. All those in favor say aye.
Aye.
Opposed, no.
Good job.
Senate Bill 199 passes. Mr. Kohler. please read the title to Senate Bill 204.
Senate Bill 204 by Senator Lambert, also Representative Rankin, concerning the Higher Education Revenue Bond Intercept Program.
Thank you. Representative Rankin.
Madam Chairman, I move Senate Bill 204.
Is there any discussion on Senate Bill 204? Do you want to tell us about Senate Bill 204 or just?
Well, if you insist, Madam Chairman. So it actually is a very important, a little bit complicated bill. It has to do with the Higher Education Revenue Bond Intercept Program. So the way this works is that institutions of higher education can use the state's credit rating instead of their own, and therefore get a little bit better rate on their bonds. But we found out, our staff did, that there was about $1 billion of this debt that we had not known about, or it was not on record. And this resulted from nothing the institutions did wrong. They were refinancing old debt and coming out with new debt at a lower rate, and there was no reporting mechanism. So what this bill does is it caps the total debt, and it sets up a reporting mechanism so that we can track how much of this debt exists. And it also sets the coverage so that the general fund appropriation plus tuition, the total debt can only equal 75% of that, and the total debt that they have, which is both intercept bond and non-intercept, can only be, the debt ratio has to be 1.5. So basically we are just setting up a control mechanism, or at least a reporting mechanism, on this intercept bond debt, which the state, in some very rare circumstance, might have to cover. So I ask for a yes vote.
Is there any further discussion on Senate Bill 204? Seeing none, the question before us is the passage of Senate Bill 204. All those in favor say aye. Aye. Opposed, no. Senate Bill 204 passes. Mr. Kohler, please read the title of SCR 002.
Senate Concurrent Resolution 2 by Senator Baumgartner, also Representative Vihil, submitting to the registered elector of the state of Colorado amendment to the Colorado Constitution concerning exemption from property taxation for possessory interest in real property if the actual value of the interest is less than or equal to $6,000 of such amount adjusted for inflation.
Representative Vihil.
Thank you, Mr. My majority, Assistant Majority Leader. I move SCR 16002.
To the resolution, Representative Vihil.
Members, as all of you know, SCR 002 is a resolution. There's no other way to do this but through a resolution. Cannot do a bill. So what this bill does, it takes care of the possessory interest problems in the state of Colorado, and there is no appropriations, really appropriate. There is some appropriations, not appropriations, but there's some money is to be paid out, but it's minimal, de minimis, I guess, because of the other issues on the ballot. So with that, I ask for a yes vote.
Is there further discussion on SCR 2? Seeing none, the question before us is the passage of Senate Concurrent Resolution 2. All those in favor say aye.
Aye.
Opposed, no. Senate Concurrent Resolution 2 passes. Mr. Kohler, please read the title to Senate Bill 169.
Senate Bill 169 by Senators Martinez, Umenick, and Cook, also Representatives Kraft, Tharp, and Landgraf, concerning changes related to the 72-hour emergency mental health procedure.
Go ahead.
Representative Kraft, Tharp.
Thank you. I move Senate Bill 16169 and the Judiciary Report.
To the Judiciary Committee Report. Representative Kraft, Tharp.
Why, thank you, Mr. Chair. So we had a glorious time in Judiciary. There's 2 amendments that were passed. One is a technical correction, striking psychiatric advanced practice nurse and substituting it with advanced practice nurse with a population focused in psychiatry or mental health. The second was that law enforcement facilities is a destination of last resort. People may be taken to a law enforcement facility only when they have demonstrated behavioral aggression or violence that cannot be de-escalated at an emergency medical services facility without the assistance of law enforcement. And we do ask for a yes vote on the Judiciary Report.
Further discussion on the Judiciary Committee Report. Seeing none. Oh, Representative Salazar.
I really need a space to be able to. Thank you.
Thank you very much, Mr. Chair. So, as we heard this bill in committee, one of the things that took place was the striking of language, as you'll find on the committee report lines 1 through 10, which basically said that the State Board of Human Services, on such a substantial issue as this bill is addressing, that they cannot have rulemaking authority over any duty or responsibility delegated to a law enforcement agency, law enforcement facility, or emergency medical services facility. I find that to be probably one of the worst things that we could do, is to hamstring the State Board of Human Services, which is overseeing this, and not being able to do rulemaking. So therefore, I move L051 and ask that it be displayed.
Amendment L051 to the Judiciary Committee report has been moved and is displayed to the amendment. Representative Salazar.
Thank you very much, Mr. Chair. So once again, this bill is quite the substantial bill, dealing with all sorts of constitutional rights and other rights involving people who are suffering from some type of mental illness. And yet, what we're telling the State Board is that they cannot have any rulemaking over this to further ensure the rights of these individuals. Therefore, that's what this amendment looks to clarify, is that there will be some rulemaking authority, and I ask for an aye vote.
Is there further discussion? Representative Landgraf.
Thank you, Mr. Assistant
Chair.
Chair. Mr. Chair, thank you for not finding me. We would ask for a no vote on this. Hospitals are very thoroughly regulated by CDPHE under both state and federal law, and expanded rulemaking authority over these facilities could create added bureaucracy and potential conflicts between department rules. Please vote no.
Is there further discussion on L051? Representative Salazar.
Thank you very much, Mr. Chair. And Representative Neville was asking me the question about what this does. This doesn't have anything to do with CDPHE. This is about the State Board of Human Services, the board that is helping oversee these very substantive issues. They have rulemaking authority, but for some reason, they are not allowed rulemaking authority on these issues here, on these issues that pertain to a person's due process rights, for God's sakes. This is the checks and balances that we need in this bill in order to move forward. I'm asking for an aye vote.
Further discussion? Seeing none, the question before us is the passage of Amendment L051. All those in favor say aye. Aye. Opposed, no? No. Amendment L051 is lost. To the Judiciary Committee report. Further discussion? Seeing none, the question before us is the passage of the Judiciary Committee report. All those in favor say aye. Aye. Opposed, no? No. The Judiciary Committee report passes. To the bill. Representative Kraft-Tharp.
Thank you, Mr. Chair. Thank you, members. So, I've worked in the mental health field for a very long time, over 25 years as a clinician, as an administrator, and as a consultant. And I think that my experience has really helped me be very sensitive to those people that are experiencing a mental health crisis. I'm also very sensitive to the work that our mental health field does. Let me tell you, in Colorado, we have one of the most innovative, creative mental health systems in the country. We have some of the hardest working people that are helping us in this system. We have nationally recognized awards, nationally recognized programs. We also have service needs. And one of those service needs is, what do we do in a time of crisis when people are experiencing mental health issues? We want to make sure that we're providing the best services that we can. In 2010, the legislature recognized this, and the legislature passed legislation asking the Office of Behavioral Health to do an assessment around what were the needs in the crisis response system. And the Office of Behavioral Health did that, and that report is currently on the web page for the Colorado Department of Human Services, if anyone wants to look at that. And the recommendation was to develop a crisis response system, which I will tell you I was very proud to be a co-sponsor, along with Representative Young in 2013, in which we at the legislature said, we will take this crisis work seriously. We invested $20 million a year. That is probably up to about $26 million a year to provide mobile services, to provide short-term counseling, to provide crisis intervention, to provide mental health holds, to provide psychiatric hold centers. So what are we doing today here with this bill? We can talk all we want to, and we can introduce all the amendments we want to talk about the needs of the mental health system, what is being met and what is being not met. But let me tell you, this bill does two small things. Sorry. So let me suggest to you that this bill does two small things. Number one, thank you, Representative Del Grosso, is that in a rural area, when there may not be any options to bring somebody who might be in imminent danger of themselves or others, that person may be brought to an emergency room. Though our emergency rooms are in a conflict, federal law says when somebody needs help, that they need to be able to help them. But state law says they can't help people with mental health issues because they're not designated facilities. That puts them in a real conflict. This bill helps them with that conflict and says that in state law that they can help those people within 36 hours. Within 36 hours, they release the person, transfer them to voluntary treatment or to a designated mental health facility. The second small piece that this bill does is it has been in law for 30 years that when the sheriffs do a 72-hour hold, a mental health hold with someone, and there is no other facility for them to bring them, they would bring them to the jail. They could keep them in that jail for 24 hours, and our bill says if you need time to transport someone the 8 hours to Grand Junction, you need to go to court and you can have an additional 24 hours. And this bill in an amendment in judiciary says you will bring those volatile, violent people who are in danger of others to that jail. So let's not get caught up into the discussion around all the needs in the mental health centers and the mental health system. This bill does two small things that will help those people that are experiencing one of the most vulnerable, sensitive, difficult times in their life around a mental health crisis. Thank you.
Representative Landgraf.
Thank you, Mr. Chair. As my co-sponsor said, the bill before you today is not a solution to Colorado's shortage of inpatient behavioral health services, nor is it a solution to the shortage of a behavioral health workforce in our state. We have a lot of work to do. Everybody recognizes that. This is a small step. Access to behavioral health care is a huge problem statewide. Rural hospitals may only have occasional visits from a mental health professional, and many rural ERs are staffed by family physicians that may not have extensive experience diagnosing mental illness. For example, a vast 24-county region in eastern and southern Colorado, stretching from Wyoming to Nebraska to Kansas to Oklahoma and New Mexico, is served by just 3 psychiatrists, and ERs are often staffed by family physicians. The bill before you today is a recognition of the system as it functions today and a technical fix that is a small step in the right direction toward enabling communities to provide the best services they can to individuals when they need it. I ask for a yes vote.
Further discussion? Representative Landgraf.
I move Amendment L054 and ask that it be displayed.
Amendment L054 has been moved and is displayed to the amendment. Representative Landgraf.
Thank you, Mr. Chair. L054 protects the data developed by law enforcement and emergency medical services facilities for reporting to CDHS, and only that information. This amendment is consistent with other parts of Colorado statute that protect similar information. The amendment also protects patients by insisting that the data remains confidential and can only be provided to the public in an aggregate format. However, even aggregate data can contain patient-identifying information, and that information should not be discoverable in order to protect privacy of all patients. For example, a hospital may create a database of patients who have been placed on a 72-hour hold in order to report to CDHS, but that may include patient-identifying information to allow a facility to properly monitor information and improve quality of care. The amendment adds protections to data collected to comply with this law. It closely mirrors existing law that applies to similar data collected for peer review, a process to evaluate appropriateness of medical care. Similar information is also protected when reported for similar purposes to a different state department. The amendment does not prevent patients from getting access to their own medical records. It does not shield doctors or hospitals from malpractice lawsuits, and it does not prevent the state from properly monitoring patient care and regulatory compliance. I ask for a yes vote on L054.
Further discussion on Amendment L054. Representative Salazar.
Thank you, Mr. Chair. And we saw this amendment in Judiciary, and we voted it down, primarily because of the clunky language involved in this particular amendment. But I want you to pay particular attention to through 11, line 11, all the way down to line 15, I believe it is. The information is not subject to civil subpoena, is not discoverable or admissible in a civil, criminal, or administrative proceeding against an emergency medical service facility. We believed that this was a separation of powers issue, that this basically intrudes upon the judiciary in being able to determine what is admissible, what is discoverable. And that's why this amendment went down in Judiciary. I would also ask that this body as a whole vote against this amendment. This is not what we do as a legislative body, is tell the judicial body what is discoverable and what is admissible and what is not. That's not our role. This is a separation of powers issue. I ask for a no vote.
Further discussion on Amendment L054. Representative Joshi.
Thank you, Mr. Chair. And members, I rise in support of this amendment, L054. This amendment basically adds the protection to the data that will be collected, and it also helps to comply with the law. So I think this is a good idea, and thank you, Representative Landgraf, for this amendment, and I ask for your support.
Is there further discussion? Seeing none, the question before us is the passage of Amendment L054. All those in favor say aye. Aye. Opposed, no? No! Amendment L054 is adopted. To the bill. Representative Singer.
Thank you, Mr. Chair and members. This is arguably one of the hardest bills that I've ever come up with or come up against. I truly appreciate the work that the bill sponsors have done. There is no perfect solution. I appreciate the first and hopefully second steps that are being made in this bill to address an issue that's been a festering wound for probably decades. But I also have some concerns about due process. When people are losing their freedom because not only of danger to themselves or others, but another term, grave disability, I believe they do need some additional modicum of due process. And with that, I move Amendment L052 and ask that it be displayed.
Amendment L052 has been moved and is displayed. Members, this is a multi-page amendment that has been previously delivered to your desk. To Amendment L052, Representative Singer.
Thank you, Mr. Chair. This moves the onus a little bit more onto our emergency medical facilities, onto the Office of Behavioral Health to say, you need to find an appropriate setting for these individuals to go when they are struggling with a mental health crisis, when they are in a danger to themselves, their others, or are gravely disabled. It talks about the procedures for who must be transferred when, and how the clock will start and when the clock will stop. It even agrees to certain time limits that go beyond the 72 hours if there are weekends. But most importantly, if you direct yourself to page 4, what it says is if you want to extend that 72-hour hold, if you want to go beyond those 72 hours, you need to go to a hearing, you need to go and have your due process done, and instead of using probable cause or reasonable cause, there needs to be clear and convincing evidence that that person has a mental illness and needs to be held over. This is fundamentally, for me, an issue not only about how we take care of people when they are struggling with what is hopefully the darkest moment in their lives, but not prolonging it because of a failure of our justice system, because of a failure of due process. The bill sponsors are right. We need more resources. This bill doesn't address that, but it addresses a first step. What this amendment does is it adds another modicum of due process to a system that deeply needs it. I encourage and I vote.
Further discussion? Representative Melton.
Thank you, Mr. Chair and members. I rise in strong support of Amendment L052 for two reasons. One, that it does introduce due process. Under the bill currently, there is not enough in due process, and I fear that the current bill is unconstitutional. I fear that without having a court actually have these processes laid out in this amendment, that we're not giving someone the ability to be able to have a court decide or determine whether or not they should be held over in a county jail. And I'm sorry, but just because you don't have the option doesn't mean that we should have the right to violate the Constitution. And I also agree with the second part in that we put in a 2-year sunset in order for the communities to really use this as a temporary measure and have the 2 years in order to then be able to address their concerns. I am, however, concerned, though, going back to the due process that the hearing has to be held within 7 days as opposed to the 72 hours. Because if you have the 72 hours and then the 7 days added on top, someone could actually end up sitting in a county jail for 10 days. And so because of that, I move L056 as an amendment to L052 and ask that it be displayed.
Amendment L056 has been moved and is displayed. This is an amendment to L052. To the amendment L056, Representative Melton.
Thank you, Mr. Chair. And so what L056 does is it removes that 7-day requirement that a hearing has to be made, and it makes it 72 hours. Members, since we're talking about a 72-hour hold, if someone is in jail or being held, they should be heard for a court within the actual allotted time of 72 hours and not granted an additional 7 days, because again, that goes beyond the 72 hours. And someone could end up spending days in a county jail or in a facility as opposed to the 72 hours as laid out and as a goal by the bill. So with that, members, I would ask for an aye vote on L056.
Further discussion on Amendment L056. Representative Willett.
Thank you, Mr. Chair, and thank you for these efforts. I heard this bill in committee as well. And ladies and gentlemen, this is a really bad way to run a railroad. This bill has been in process for 2 years. All sorts, what are the amendment numbers? I mean, 56 amendments. And in judiciary, we hear another 7 amendments, I think all of which just about we rejected for a variety of reasons. I felt sorry for the sponsors, and thanks to them for bringing this bill. And at the end of judiciary, after some 2 or 3 hours of hard work, we hear there's going to be floor amendments to deal with due process. Are you kidding me? We're in committee for hours with judges, with hospital administrators, with experts in mental health, with experts from small town judiciary and law enforcement dilemmas, studying this stuff. And then on the floor, we get amendments to sunset the bill, to put in due process. For 30 years, we've had nothing. I mean, you talk about no due process and a goofed up system for the mentally ill. This is what we've had. Now some members bring a good bill that we could get across the finish line, and we start seeing amendments like this that just derail the process. Now, I'm not up here saying people aren't entitled to due process, but I am a guy from rural Colorado. I do understand there's a fine line between someone who's a threat to themselves and others and who's simply mentally ill, and between that and an Aurora shooting or what just happened down in Colorado Springs with that nut job. And at some point, we have to have a system to take these people and get them under control. I asked during committee hearing about telehealth. I didn't know much about this. Thought it might be a naive question. They said, no, Rep. Willett, you're on to something. We need, in these small rural communities that J. Paul Brown knows about, and out in eastern Colorado we know about, southwestern Colorado, San Luis Valley, we know of these areas. Our sheriffs have to have a system, our courts have to have a system to take some, and we can do something with, it doesn't have to be a barred cell room. It can be a safe facility, get telehealth, deal with the people, get them medication, but to start putting numerous problems onto this system, it is at the risk of public safety. And I'm sorry, folks, if I have to make the call here, I think with probable cause and the due process that's already built into this bill, we're fine. We're also not fine with any kind of a sunset on this until we get all sorts of money or we figure out broadband and telehealth to rural Colorado. That's your answer. So I would urge a no vote to both of these amendments and any other amendments to this bill tonight. This thing was barely squeaking through judiciary. We need to leave it as is, respect these sponsors, respect all the stakeholders that got this thing close to the finish line and not derail it.
Representative Salazar.
Thank you, Mr. Chair. And we are respecting the sponsors, but we're also respecting those in rural communities. Because as was just said, this statute's been in existence for 30 years with no due process whatsoever. And what this bill does is it extends out the amount of time that you can hold somebody in a jail facility without due process. So that doesn't even make any sense. Doesn't make any sense whatsoever that the way that the law is currently written, there's no due process, but now what we're going to do is we're going to extend it out even further and give them no due process. That's what this amendment was about. And if I remember correctly, on judiciary, we tried talking about due process and we were told that there might be a deal. Let's get this through and then we'll deal with, and hopefully there will be due process. Well, guess what? The deal didn't go through. That's why we're on the House floor dealing with due process. Now, there were people who came and testified in opposition to this bill, and one of the things that was said that struck me so heavily was that criminalization of the mentally ill is a practice that we saw in the 18th and 19th century. And that's exactly what this bill gets back to, is that we're going to criminalize the mentally ill without due process. They will be held in jails. And under this bill, they're going to be held in jails for a good period of time. Particularly if it happens on a Friday evening, you have Saturday and Sunday, and if it happens around Memorial Day, it will happen on Monday without due process. How fair is that? particularly to those in rural areas. You might be lucky here in the Denver metro area where you might have a place to go to, a mental health facility to go to. What we heard is that in the rural areas, you don't have those mental health facilities. So what's the resort? Throwing them in jail. So not only do we have due process problems, but now we got an equal protection problem because rural folks are being treated differently than those in the metro area. That's what this amendment is trying to fix. I don't know why anybody would have any problems with due process, particularly for the mentally ill. Imagine someone having a mental illness and being thrown in a jail. And they have to be in there by themselves. That's the rule. That's the law. They have to be in that jail by themselves, in that cell by themselves. They have to be separated from everybody else. Is that the compassion that we're going to show? Someone who's having a mental health crisis? Someone who hasn't even been charged criminally. They're not even charged criminally because it's not a criminal violation to have a mental health issue. That was the other thing that came up in committee. Members, this amendment addresses so many of the concerns that we heard from the opposition. Why wouldn't we listen to those concerns? Why wouldn't we afford due process to individuals? Why wouldn't we do that? To do otherwise is just cruel. And it's particularly cruel to those in rural communities because there's not the resources out there. I ask for a yes vote on this amendment to the amendment L056.
Representative Melton.
Thank you, Mr. Chair. And members, I want to clarify something. I did make a mistake and say in jail. The amendment is actually dealing with in custody for in emergency rooms. However, the person is still in custody. The person is still handcuffed to a bed. And so, could be. Either way, the person is in custody against their will. Can we agree on that? The person's in custody against their will. And when you're holding someone against their will, whether you're in an urban area or in a rural area, you should have your rights respected and protected. You should have due process. And so what this amendment does is it says, we're not going to hold you for 7 days just simply because we may not have the resources to move you elsewhere, just simply because we don't have the resources to respect your rights. It says that within 72 hours, you will get due process. And so with that, members, whether you're in the urban area or rural area, this is a good amendment to protect your right to due process. I ask for an aye vote.
Is there further discussion on Amendment L056? Seeing none, the question before us is the passage of Amendment L056. All those in favor say aye. Aye. Opposed, no? No. Amendment L056 is lost. To Amendment L052. Representative Kraft-Tharp.
Thank you. So thank you very much for the vigorous conversation. So we are opposing L042. Let me just go through a couple of points very briefly. 5-2. Oh, well, 4-2 also. But 5-2.
That was a month ago.
So one of the things that Representative Singer said when he introduced this is that it places the onus on the emergency medical facilities and the behavioral health care centers. So one of the difficulties I have with this bill is that a person is brought to the emergency medical facility, and according to the amendment, within 24 hours, they call the Office of Behavioral Health, who in this amendment assists. So where is the onus of responsibility? The onus of responsibility is placed on the emergency medical facility. That possession seems to be responsibility, and I think that's wrong. Number one. Number two, there is the repeal within 24 hours. Representative Melton called it a sunset within 24 hours. But this is repealing only the jail, the law enforcement facility usage. So that's a wonderful, I will say a laudable goal. But what that means is that in 2 years, our sheriffs go out to assist people in a mental health crisis, and people who are violent, people who are in danger of others, and they do not have the option to be able to bring them to the jail. What will happen? And I want to suggest a couple things will happen. I want to suggest that those people may remain in the back seat of the car. I want to suggest that those people may have criminal charges placed on them so that then the sheriffs do have the option of bringing them to the law enforcement facility. There are numerous reasons why that repeal does not work. But the other is that the 2-year repeal is a way to tell the legislature, deal with this situation. Well, this summer, in this bill, the Department of Human Services is mandated to pull together a group of stakeholders, do a needs assessment, come up with a plan, come up with a budgetary plan, present that to the judiciary and the human services field next January. Representative Landgraf, would you like to talk about the due process part of this?
Representative Landgraf.
Thank you. I would love to talk about this. There are 11 counties in the states that do not have a hospital. So it's exactly like she said. If somebody is in a mental health crisis, where are they supposed to go? And I would say that due process kind of works both ways in that if somebody is having a mental health crisis and you have no place to take them and you just dump them on the street because you can't put them in a hospital, you certainly can't keep them in the back of a police car, that's not really very good care. We do not need this because under existing state law, a law enforcement official or healthcare provider must have probable cause to believe that the person appears to be in imminent danger to themselves. And Colorado courts have held that probable cause is sufficient due process for emergency custody. That has already been proven in court. No amendments are needed because healthcare providers are currently held accountable and patients are protected by the medical standard of care and federal law. The medical standard of care says that doctors and nurses must follow the best interest of the patient and continuously reassess the patient for evolving needs. Federal law, EMTALA, ERs are required to screen and stabilize emergency medical conditions, including psychiatric emergencies, before admitting, discharging, or transferring them to an appropriate level of care. In other words, patients only stay at an emergency facility if a doctor or nurse considers their condition emergent, in which case federal law prohibits the hospital from discharging the patient. So we have to align federal law for the hospitals with state law. We'd ask for a no vote.
Further discussion? Representative Singer.
Thank you, Mr. Chair. Members, I won't belabor this anymore other than to say I once again appreciate what the bill sponsors are trying to do, but if someone is truly gravely disabled, if someone is truly of risk at harming themselves or others, what is the problem with using a clear and convincing evidence standard? That's the question that I'm asking. That's what this amendment does. Please vote yes on Amendment 5.2.
Further discussion? Seeing none, the question before us is the passage of Amendment L052. All those in favor say aye. Aye. Opposed, no? No. Amendment L052 is lost. To the bill. Representative Landgraf.
Thank you, Mr. Chair. I'd ask for a yes vote on the bill.
Further discussion on Senate Bill 169. Seeing none, the question before us is the passage of Senate Bill 169. All those in favor say aye. Aye. Opposed, no? No. Senate Bill 169 passes. Mr. Kohler, please read the title to Senate Bill 208.
Senate Bill 208 by Senator Hill, also Representatives Williams and Sias, concerning maintaining the same funding calculation for a charter school that converts from a district charter school to an institute charter school or from an institute charter school to a district charter school.
Representative Sias.
Mr. Chair, I move Senate Bill 208 and the House Education Committee report.
Representative Sias, there actually aren't any committee reports to the bill.
We don't have one.
Representative Williams.
Thank you, Mr. Chair. And members, basically what House Bill 208 does is we want to ensure that when a school district that is authorized in a charter school, when it transfer from the Charter School Institute, basically CSI, authorized charter school, it continues to receive the adjusted per pupil revenues and at-risk supplemental aid using the funding formula that is applied prior to the transfer. It also ensures that the CSI authorized charter school that transfers from a school district to the authorized charter school continues to receive the adjusted per pupil revenues. And so basically, members, what this does is it ensures that we have transparency and certainty. It says whatever type of funding you have today is the funding that you will have tomorrow, and we would like to ask you for an aye vote.
Further discussion? Seeing none, the question before us is the passage of Senate. Representative Brown. Representative Brown? Representative Brown.
Thank you, Mr. Chair. And I'm not sure I'll ask the question, but it's my understanding, it's always the charter schools have always been under school boards. School boards approve charter schools. It's a local control issue. If we are going to mandate at the state level how much charter schools are going to get, then maybe we ought to have two. We ought to have public schools, a public school program, and a charter school program, and us just take over the charter schools. Maybe I'm wrong about that, but I'd like to have that discussion.
Representative Sias.
Thank you, Mr. Chair. And Representative Brown, just to be clear, we have charter schools can be authorized either by a district or by CSI, existing law. All this bill does, to be very clear, is whatever the funding formula, and schools can shift back and forth between being a CSI school or a district authorized school. They can go back and forth between those for a variety of reasons. All we're saying is that the funding formula that applies to them at the time that they make that transition, in whichever direction they're going, is then locked in as the funding formula that exists going forward. It has no impact on the amount of money that the district is spending. It's just locking in certainty for the school going ahead. And it's not changing who authorized the school, who has control of the school. It's just if the school makes a change based on what it is able to do under current law, that level of funding is locked in. And I think it's very easy to confuse this bill with some others that were up regarding mill levy equalization. That is not this bill, sir.
Is there further discussion? Seeing none, the question before us is the passage of Senate Bill 208. All those in favor say aye. Aye. Opposed, no. Senate Bill 208 passes. Mr. Kohler, please read the titles. Madam Majority Leader.
Thank you, Mr. Assistant Majority Leader. I move to proceed out of order for the immediate consideration of House Bill 1468 by Representative Kay Becker and Speaker Hollinghorst.
You've heard the motion. Seeing no objection, the committee will proceed out of order for consideration of House Bill 1468. Mr. Kohler, please read the title of the House Bill 1468.
House Bill 1468, Representatives Becker, Kay, and Hollinghorst, also Senator Stebbins, concerning costs that may be deducted by the taxpayer, transportation, manufacturing, and processing costs for purposes of calculating the net amount realized by the taxpayer for the sale of oil and gas.
Representative Becker.
Thank you, Mr. Chair. I move House Bill 1468. There is no committee report.
To the bill, Representative Becker.
Thank you, Mr. Chair. I'm sure some of you, if not all of you, are aware that on April 25th, a very impactful Colorado Supreme Court decision was issued on severance tax. That Supreme Court decision has the effect of requiring the state to immediately come up with about $115 million in this fiscal year to make available for new tax refunds that we didn't know were coming from oil and gas. A separate bill deals with how we're going to come up with that $115 million. This bill only deals with the prospective issue of the significant loss of severance tax dollars. On average, about $19 million per year. Now, where is that going to be felt? That $19 million goes half to Department of Natural Resources for important things like water projects, phreatophyte removal, low-income energy assistance programs, you name it. The other half goes to local communities. Some directly impacted by oil and gas. The vast majority of it spread across Colorado to help local governments when they apply for a variety of programs. This bill simply says we are going to back to the interpretation we had before the Colorado Supreme Court decision on April 25th. Now, in committee, what we heard is this is a surprise. Yes, absolutely. The Supreme Court decision was an absolute surprise, given that the lower courts had ruled in favor of the Department of Revenue interpretation. The other thing we said or heard was, let's have a conversation about this. And we said, fine, let's have a conversation about this and turn this into that bill. And then it turns out folks don't actually want to have that conversation. The last thing we heard was, we don't know what direct impacts are. And so I have an amendment for that. But all we're trying to do is go back to the interpretation that has existed in law for many, many years that describes what things can be exempted from severance tax. And that's been the law for a while. And changing that law has had a $19 million annual impact on the state of Colorado budget. And I ask for an aye vote.
Madam Speaker.
Thank you, Mr. Chair, and I can't add too much to the explanation that my colleague Casey Becker did, but I will say that this is a bill that will attempt to address, basically in the short term, an issue that has come up at the last minute that is bound to have a significant impact on local communities and on the state in the programs that they ordinarily provide with severance tax. And as you know, that's been an important priority for us this year and continues to be. Severance tax provides a tremendous amount of support to communities and to the state to take care of the impacts long-term of mineral extraction and to do it the right way. Now, there probably needs to be a longer-term discussion about severance tax. I think what's happened here with this issue just tends to point that out. But this is a way to deal with what can be a much higher liability than just the potential $115 million that we're talking about just for this year and the 2 years before it, just to take care of the deductions that will be claimed based on this lawsuit. This could be a much higher liability if we don't make a few changes that are simple, that take it back to the original estimates of how this should be working, the way it has been administered in the past. I ask for a yes vote on this bill.
Representative Wist.
Thank you, Mr. Chair. I'd just like to start with a question, and that is,
Why was the bill not referred to the Finance Committee and Appropriations? Certainly looking at the House Committee routing rules dated January 8th, 2016, any bill with a fiscal impact in the fiscal year must be referred to the Committees on Appropriations and or Finance. So just a procedural question for sponsors.
Madam Speaker.
Thank you, Mr. Chair. The routing sheet is designed and written and enforced by the Speaker, can be waived by the Speaker, did so in this particular instance because we needed to discuss this issue on the floor and move it forward if we could. The appropriation is very straightforward.
Representative Wist.
Thank you, Mr. Chair. Well, if there's an urgency to not referring this to Finance and Appropriations, I'd simply say that to deal with the refunds, that's already dealt with in a separate Senate bill. I believe the number is 218. We're talking about the prospective result going forward and how we're going to collect these severance taxes going forward. But let's be very clear. This is not reverting back to the policy the way it used to be. The proponents here are arguing for the policy that they thought was in existence, and the Supreme Court ruled unanimously against them. Unanimously. Not even a close call. My friends, this is a tax policy. This is a change in policy that results in increase in revenue. This requires a vote of the taxpayers. And in fact, the fiscal note specifically says this tax policy change may need to be referred to voters. I don't think it's may. I think it has to be referred to the voters. Proceeding with House Bill 1468 at this juncture creates some serious constitutional questions. Strongly urge a no vote.
Mr. Minority Leader.
Thank you, Madam Chair. I also want to comment on something we just heard from one of the sponsors. They said, wow, this is something we just found out about. This is kind of a surprise. This is a shock. Well, the reality that this lawsuit has been out there since 2010. So this should have not been a surprise to anyone. This is 2016. So the fact that this has been out here since 2010. And I think the fact that the Department of Revenue, we knew this was in front of the Supreme Court, and the fact that the Department of Revenue did not let this body know, they didn't let the JBC know that this was a potential that this ruling could happen, and this could be this kind of a financial impact on this body, quite frankly, is irresponsible by the Department of Revenue. Quite frankly, this is a panic decision to get this through at the end of the session. This has a change in tax policy, which, by the way, we've had some other bills in the past, for instance, the Dirty Dozen that came through, but those got rid of an exemption. And so those were ruled legal by the Supreme Court, but that was getting rid of an exemption. This doesn't get rid of an exemption. This changes tax law, tax policy, which says clearly in our Constitution that a change in tax policy must go to the voters. And yes, we keep saying, well, this has always been kind of unclear in law. Let me read what we're striking out. That less any deductions for any transportation, manufacturing, and processing costs borne by the taxpayer. So this has been clearly in law. This is something that has been followed, and all of a sudden the Department of Revenue decided to change, and we say we want to bring it back to the way it used to be. Well, the way it used to be was ruled illegal by the Supreme Court. Members, to make a change in tax policy this late in the session without having any kind of stakeholder input, quite frankly, this bill wasn't even in people's bill folders when the committee actually came through. It wasn't even online. So any stakeholder that might have a process in this didn't even know the bill existed, why the bill was in committee. Members, that is why I urge a no vote on 1468.
Further discussion? Representative Neville.
Thank you, Mr. Chair. And members, we heard over and over in committee that this has to be done this year because next year we might get Tabor refunds, so this would have to be sent to the voters. I think that's clear and convincing evidence that this is a change, significant change in tax policy and should be referred to the voters. But beyond that, we also heard in testimony that this policy, the change in DOR policy, the industry's been arguing against this for over 13 years. Over 13 years, the lawsuit's been there since 2010. So we heard that there's a problem and there's a problem here. And I agree there is a problem. And the problem is DOR misinterpreted this. DOR massively failed. And the Supreme Court put them in their place. So the answer now, after 13 years of going through this, is not to jam through a bill with less than 72 hours left in the session. I urge a no vote.
Further discussion? Representative Leonard.
Thank you, Mr. Chair. There's also been a case we heard in committee today that this is just a closing of a loophole, that we've had this issue out here. The oil companies, gas companies have missed it until 2010 when they filed the lawsuit. It took 5 years, and they go back 3 years in order to be able to get back their tax money that they paid. Of course, they couldn't go back 8 years to get all of it. But the state kept the difference, and it's basically the opponent's argument is really to say, well, we collected the tax, we'll have to pay $115 million back for everything that we collected because the Supreme Court said we have to, but it's a loophole, so we're going to close it. But we heard testimony by the oil and gas that it's not a loophole. It's actually the reason for the specific deduction of the cost of capital in here is because it is an actual cost that has to be deducted before income is calculated after revenues are received. So it's a very fair and normal deduction that the industry does have, and it is inconsistently collected. That some of the oil and gas companies who use third parties to be able to deliver and transport gas are able to very easily calculate what their costs are. But others that are affiliated have a more complicated time, and so that's what the BP issue is all about. So if you hear arguments that this is just a closing of a loophole, we get the right to be able to do that, the government giveth and taketh away, that's the end of the story, that in and of itself is going to give new lawsuits because that isn't something that is consistent with our law to be able to calculate those deductions. So I would urge a no vote on this bill. Thank you.
Representative Foote.
Thank you, Mr. Chair. And I guess I probably can't dispute the possibility that this could lead to more lawsuits because we've seen that, unfortunately, from the industry, and it could lead to more lawsuits, just like we've seen in the past on many different issues when they disagree with the outcome. But one thing that I heard at the beginning of this, which I thought was interesting, was there was a discussion about actually turning this into some kind of a study, which the industry ultimately rejected. And I guess from their perspective, I can understand why they would want to reject that and why they don't want us talking about it, because it's clear if you were to go up and down Main Street in your districts or my district and you talk to somebody about what's going on, they would see it for what it is, which is a blatant loophole, and they're paying their severance tax. And unfortunately, it's not the only one. There are other loopholes in place right now where the oil and gas industry actually has bigger loopholes than the taxes they pay for severance tax. They pay an average, a 10-year average of $150 million a year in severance tax. The loopholes that currently exist, not including this one, is a 10-year average of $250 million when you include the ad valorem tax credit and the stripper well tax credit. So they already have bigger loopholes than they're actually paying in severance tax. This particular loophole will be even bigger. And this bill is actually a modest bill in that regard. It doesn't close the biggest loophole that exists, but it does close one that's in front of us right now that was brought to our attention from this Supreme Court case that they decided just recently. It's a proposal that makes sense to do. It's a proposal that's good for Colorado. And I hope that we can talk about it more, because I think the more people learn about what's going on with the severance tax, the regional inequities of the severance tax, the loopholes that exist, particularly with ad valorem and stripper well and now this new one, the more they're not going to like. And the more they're going to want us to close the loopholes like they asked the legislature to do in good fiscal tax policy that we should be doing down here in Colorado.
Representative Wist.
Thank you, Mr. Chair. Why do our decisions result in lawsuits? Well, it's because they're bad decisions, because they're not based on good law. When a unanimous Supreme Court says to the Department of Revenue that you messed up, you got this wrong, and that continued action going down this path will result in litigation, I don't think it's an unreasonable position for us to say that no more. We're going to stop passing laws that don't pass constitutional muster and that do not make sense. Let's look at what the specifics of this bill do and see if this sounds like a loophole to you. Well, first of all, the bill changes the language in the severance tax statute, allowing deductions from the downstream selling price for any transportation, manufacturing, and processing costs borne by the taxpayer to the direct costs actually paid by the taxpayer for transporting, manufacturing, and processing. Number two, the bill would eliminate deductions for any costs that are not direct costs, but it doesn't define direct costs in the bill, so we're going to have some litigation about what the definition of direct costs are. The bill also requires that costs must be actually paid by the taxpayer. So royalty owners and non-operating working interest owners pay severance tax and are taxpayers. The bill would likely have the effect of eliminating deductions for royalty owners and non-operating working interest owners, since they do not actually pay the cost. So another issue for likely litigation, another issue for confusion. The bill converts a tax on severance, this is a key one, measured by value at the wellhead to a modified gross receipts tax. And this is not consistent with the history and prior understanding of the severance tax in Colorado. It's been well settled for many decades. The bill would also create discrimination between operators who invest in and operate their own transportation and processing facilities, and those that hire third parties to provide transportation and processing services. So, members, this is not a minor tweak. We're not closing a loophole. This is major tax policy that's being pushed through in the last 72 hours of this session. This is a complicated issue, and yes, the Supreme Court decision did create an issue for us to address, and that is how we're going to pay these tax refunds that will be requested. That is not covered by this bill. I want to make sure that that's perfectly clear. That issue is not being addressed here. This is talking about massive changes in prospective tax policy going forward on the way we're treating severance taxes. This is a significant deviation of what we've done in the past. Don't be fooled. This is not fixing a loophole. This is rewriting tax policy. Urge a no vote.
Representative Sane.
Thank you, Mr. Chair. And members, when we talk about loopholes, let me make you aware of one that rural Colorado fills all too well, a particular loophole that allows the General Assembly to sweep severance tax, to sweep that fund to the tune of $400 million over the last 9 years. I don't see any complaining about that. I don't see any complaining about sweeping that money out of there, and if we had kept that money in there, we wouldn't be having a problem right now. Let's shut down that loophole before we talk about loopholes, and I understand we've spent a lot of money. We've spent too much money. I bet there's a lot of things we can cut in the budget right now. And this particular bill would just pad the budget just a little bit more like we've been doing over the last 9 years. I'm going to urge a no vote on this bill for many, many, many reasons, the least of which is pushing us through in the last 72 hours. It's irresponsible. Urgent no vote.
Representative Becker.
Thank you, Mr. Chair. I think you bring a great point up about sweeping severance tax. I wasn't particularly happy about that, but it happened. $20 million last year. This change, this Supreme Court decision, has an annual impact of $19 million that disappears from severance tax revenues. Doesn't go to your communities or your communities or your communities. It's gone. So if it was so outrageous to sweep severance tax into the general fund, which largely went to K-12 education, why isn't it just as outrageous to say, oh my gosh, we're going to lose that exact same amount of money every year? And that impacts our communities. I'm going to read to you one of the grants that my communities just got. Because we all get these emails. Here's one for the Jamestown fire reconstruction, which was destroyed in the 2013 fires. Here's a grant in the amount of $598,000 to assist with the above-mentioned project that comes from severance tax. I could read these on and on and on. That money is disappearing. Our communities that are impacted in all sorts of ways and get local grants from severance tax won't have that opportunity because $19 million annually is going to be gone. Another thing we hear about all the time is water projects. Half of the severance tax we collect goes to DOLA, half of it goes to DNR. All those Tier 2 programs are going to be impacted unless we come up with another formula. Tier 1 could be impacted unless we come up with another formula. Those are important programs throughout the state of Colorado. This isn't an attack on oil and gas. This is simply saying we rely on this money. Local, rural communities rely on this every day for assistance in all sorts of day-to-day projects that they have to do that they don't have the money for. This decision is a major impact to the people of Colorado, and we just want to get it back to where it was before, because we should be collecting severance tax. Severance tax is the government, and every state has it. I think almost every state has it, is their way of saying this is a non-renewable resource that future generations don't get to benefit from. It's a one-time extraction, so we need to have a tax that says we're going to make long-term investments for the future of the people of Colorado. But Colorado is one of the lowest severance taxes in the nation. The effective tax rate for severance tax is 1.5%. With this Supreme Court decision, it's even lower, $20 million annually. So that's about a 15%, 13% decrease in severance tax annually. That's a huge impact. I think that matters. I think if we're representing our communities, we want to get back to where we were. That's all we want to do. And if we try and do this next year, and we're in a Tabor refund, we can't run that bill at the legislature. We can try and do a referred measure that would put it on the ballot. That's the best we're going to get. So how are we going to make up that money for local communities? Where is that going to come from? I'd like an answer to that. Where's the money for those water projects going to come from? Where's the money for the Jamestown fire station project going to come from? Because they have to have a fire station that was destroyed in the floods. What would they do? I ask for an aye vote.
Representative Rankin.
Thank you, Mr. Chairman. And I probably have a little bit different take on this. Actually, my district, 3 counties, actually do contribute the bulk of the severance tax money. And that's because my counties have a low property tax, and so the oil and gas companies can't deduct very much from their severance tax payment. So, I really actually do thank you for Representative and Madam Speaker for trying to fix this problem, because it really is it's going to be a tremendous, terrible impact on the counties I represent. But on the other hand, this is a big issue. Maybe we ought to be thinking about equity county to county. maybe we ought to be thinking about where the money's actually being spent. There's no correlation, by the way, between impacted counties and the grants that are issued. So maybe we ought to be thinking about the details of tax policy and the definitions. When I go talk to the oil and gas tax lawyers, they're talking a whole different set of terminology and language. So, I think we need to look at our tax policy. We need to look at it very, very hard. We need to, perhaps we should compare ourselves to other states and see how we stand and see what's fair to our oil and gas. Perhaps we ought to look at our cost of regulation as a cost. But these are not simple issues. And my view is that we need to be very carefully consider this. We debated this issue and how to get through this year in JBC for many hours last Friday. I think we have a good bill for you on Senate Bill 218, which will be coming over. So we can get through it. We've got a plan. But at the same time, I don't think we should rush into this. In fact, maybe it should go to the voters. Maybe that's the right answer next year. So I don't think we should rush into something where we don't even have the right definition of terminology and to put into tax policy just because we're trying to avoid going to the voters next year. So thank you for the effort. I honestly, I understand and I appreciate it from my constituents, but I just don't think we ought to get there in this time frame. So I would ask for a no vote.
Representative Brown.
Thank you, Mr. Chair. If you don't have an industry, then you don't have anything. You don't have those water projects. You don't have those projects at the local government. So we want to make sure that we don't kill the goose that lays the golden egg. This bill is a massive change in tax policy. And it should not be passed on the spur of the moment. And in my opinion, this is the spur of the moment. Should not be passed. It's another, in my opinion also, another assault on one of the most important industries in our state. And I would ask for a no vote on 1468.
Representative Neville.
Thank you, Mr. Chair. And members, I kind of want to set the record straight because we keep hearing we're losing out on severance tax money. We're not losing out on any severance tax money. The fact of the matter is we've been wrongfully taking severance tax money for over a decade. The real crime here is that these folks can only go back 3 years to amend their taxes and recoup that when we've been collecting it from them for over a decade, wrongfully so, ruled unanimously by the Supreme Court. So let me set that record straight. We are not losing out on any money. We took the money wrongfully in the first place.
Representative Foote.
Thank you, Mr. Chair. And, we many times hear in these debates that if we do something, and in this case, if we close this loophole, then the industry may just end up moving out. But my question is, where are they going to move to? Are they going to move to, say, Oklahoma? Oklahoma, actually, the entire tax rate that oil and gas pays in Oklahoma is double what they pay here. What about Wyoming? Well, we heard testimony that actually the tax rates that the oil and gas pays here is 1/3 of what they pay in Wyoming. Same goes with North Dakota. So that argument doesn't really hold much water because the bottom line is, and it is the case, that the industry pays some of the lowest taxes in the country right here in Colorado. The severance tax, for example, in North Dakota is about 10.5%. The effective severance tax rate here with all of the loopholes that oil and gas enjoys is about 1.5%. That's how much they pay here in Colorado. So if we close this loophole, it's going to make somewhat of a difference, but it's still going to be low. It's still going to be lower than the other states. It's going to be lower than Wyoming. It's going to be lower than North Dakota. It's going to be lower than Oklahoma, lower than other states. One thing that I wanted to just clear up was the nature of this Supreme Court ruling. It was not a constitutional ruling. This ruling was based on statutory construction. And of course, as you know, that's something that we can control here is the statutory construction. What the Supreme Court held was their interpretation was, and of course that's the law of the state now, is that, and in the case of this particular tax deduction, transporting is the same as capital for all intents and purposes. So therefore, it should have the same deduction as transporting does. We can change that, and that's what this bill is aiming to do. We can change that just like we should with our tax policies and make sure that it's tight and make sure that we don't have loopholes that industry continues to take advantage of unfairly. You know, I think this bill comes down to priorities, and we hear that all the time here in the Capitol, that we should have priorities. Really, is it our priority that we continue to give oil and gas industry loophole after loophole in this case, where they continue to take advantage of these things and take down their effective severance tax rate from something that was low in the first place, it's about 6%, which is right the middle of the road in the first place, if not low, all the way down to the lowest in the country. Should we continue that? This bill is something that allows us to address that, and it should be supported.
Representative Sane. Representative Klingenschmidt.
Thank you, Mr. Chair, and thank you, Representative Foote. You know, I lived in North Dakota for 5 years, and although their severance taxes is higher than ours, they don't have a property tax there. So if you'd like to trade and say, well, okay, we'll increase the severance tax here, but we're going to get rid of everybody's property tax, then I might support you, but not this year. Well, that's a longer discussion, and we'll have to have that discussion next year. And I also want to thank the bill sponsors for trying to resolve this discussion that came because of the surprise ruling by the Supreme Court we were all not expecting. And I understand the late discussion. But Representative Becker, you seem to represent that, oh, it's all severance taxes that are going out the window. That's not what the Supreme Court decided. It's only a limited set of severance taxes that were collected improperly. And for DOR to have collected those improperly, a small subset of the big pot of money that we're still going to be collecting on the severance tax, this small subset is illegal and was ruled illegal. And we shouldn't be, fixing that which the Supreme Court says is the wrong way to do it. DOR, as Representative Neville said, has been collecting this illegally for years. And the fact that they got caught doesn't necessitate that suddenly we've got to come in and make their bad process into a new law. It was a bad process. We shouldn't repeat their error, and we certainly shouldn't put it in Colorado statute. I urge a no vote on 1468.
Representative Priola.
Thank you, Mr. Chair. Members, I rise in opposition of 1468. Reading the opinion, to me, it looks like Revenue got their hands caught in the cookie jar. In a sense, it looks like Revenue's been running a tax haven for many years. And many employers around the state complained and disagreed and said, look at the law. Look at the law. You're not applying it correctly. And they were ignored for a decade or so. And finally, it took an employer to stand up to Revenue and say, this isn't right. And the Supreme Court agreed. The Supreme Court said, no more. No more tax haven Revenue.
Representative Brown.
Thank you, Mr. Chair. And Representative Foote, I will tell you that the oil and gas industry will leave the state and have left the state. There's a whole bunch more at stake here than just taxes. You know, I've got friends that are in the industry, and they can go to Texas and get a permit in 10 days, where it takes 2 or 3 years here in Colorado. They can go to any other state and go with less regulation, less red tape, and get it done. So this may be the nail in the coffin for many of those in the industry here, and it's absolutely, this bill is not needed, and we need to take our time and think about this some more. And another thing, you've got on top of your severance taxes, you've got property taxes that your oil and gas companies are paying, and it is much more than what you are saying. So I would again ask that you vote no on 1468.
Representative Wist.
You know, we've spent some time in this chamber talking about litigation reform and the concept of loser pays. Well, let's talk about what this bill is. It's actually winner pays. The operators won this lawsuit, and what this bill is asking us to do is to punish them. It's to force them to pay for the remedy the DOR couldn't get on their own. So when you go to court and you challenge a government action as being not supported by the law, and you win that case unanimously at the Supreme Court, is the appropriate response that we punish you? Because that's what this bill does. It punishes industry and rewrites the law that DOR thought that they had. I'd suggest to you that that's not the way that we write tax policy, and that's not the way that we regulate our business community. This results in an unfair penalty on them, and I'd suggest to you again, does this look like a loophole? And my friends, it's not a loophole. It's a major change in tax policy.
Representative Foote.
Thank you, Mr. Chair. And unfortunately, I didn't bring the book that I should have brought today. I didn't realize this debate was happening today. But it's a book that I've read to my kids a couple times. It's called The Boy That Cried Wolf. And you all know the book. And of course, the lesson is replayed here again and again. I can't tell you how many times since I've been here in 2013 I've heard that exact same thing. If we do this to the oil and gas industry, it's going to be the straw that broke the camel's back. They're all going to move. They're all going to go somewhere else if we do this. And you can go all the way back, at least in what I've studied, all the way back to the COGCC reforms in 2007, 2008. It was said again and again and again. If we do this, the industry is going to move. If we do that, the industry is going to move. And for example, if it really is the case this time that the wolf is real, and they do move, and they move to Texas, for example, or Oklahoma, or North Dakota, or anywhere else, I can guarantee you one thing, wherever they move, they're going to pay more taxes than they pay here.
Representative Becker.
Thank you, Mr. Chair. I just want to be clear, would this be the nail in the coffin that would send oil and gas out of here? No, because they've been paying it for the last several years. They've been paying it. But they challenged it. They said, our cost of capital, that cost of capital is what we could have made if we had invested, I don't know, in Apple stock, for instance. You name it. That cost of capital is a deduction we should be able to make as a transportation, processing, or manufacturing cost. The cost we didn't invest in something else that we forewent for investing it here is a transportation, manufacturing, or processing cost. That's what the Supreme Court said. So now all those costs get to be deducted from what they pay on severance tax. I don't think Department of Revenue's longstanding interpretation was unreasonable. But the Colorado Supreme Court said the General Assembly didn't write the law well enough, and if they want to rewrite it, they can. And if we don't rewrite it, communities are going to lose out about $19 million a year going forward. So I just want to clarify that. The other thing we heard is, well, now you've changed, we don't even know what direct costs are. So with that in mind, I move L002 and ask that it to be displayed.
Amendment L002 has been moved and is displayed to the amendment. Representative Becker.
So as I mentioned, there were a few things we heard in committee. One was, let's have a conversation about this. We can explain more to you about severance tax, about how, what would make sense. And then, we'll just talk some more. And so I said, all right, I'll turn the bill into that. And they said, actually, we don't actually want that conversation anyway. The other thing we heard is, what do direct costs mean? Because our bill says you can deduct your direct costs for transportation, processing, and manufacturing. That's what you get to deduct. Not anything absolutely possible like what you hypothetically could have invested somewhere else. So this simply clarifies what the direct costs for transporting are, direct costs for processing, and direct costs for manufacturing. Just trying to respond to the concern that was raised in committee, and I ask for an aye vote.
Further discussion on Amendment L002. Representative Sane.
Thank you, Mr. Chair. Well, this is interesting. So not only are we going after the oil and gas industry for a mistake DOR made, but we're going to attack the entire value chain here with this amendment. We're attacking the entire value chain, even to the new products that are being made. That's what this amendment does. There's a lot of things that are products of oil and gas. Some of us are wearing some of those things. There's a lot of products that oil and gas makes, and including medicines. There's a lot of things that can be made. This attacks a lot of different industries. I'd urge a no vote on this amendment.
Further discussion on the amendment. Representative Leonard.
Thank you, Mr. Chair. If we didn't think this was a discussion about tax policy, it certainly is with this amendment. Because now what we're going to do is we're going to tell the oil and gas industry what their costs are. Because what's cut out of here are costs that are not direct, like depreciation. So what we're going to say is all these very capital intensive industry, we're going to say that all those depreciation costs are not direct. You build something and you get a life on that, and you get to depreciate that item as an indirect cost, that even though you were able to do that before with the cost of capital, now you can't do that, says this body. And that has nothing to do with the actual cost of running that business and delivering oil and gas. It's an actual cost that needs to be done or actually paid. Like we heard in testimony today, we are going to have lawsuits challenging the word direct and challenging the word actually paid. And this is now deep inside what tax policy is going to be. And I would definitely urge a no vote on this amendment because it doesn't reflect the industry, it doesn't reflect the costs, and all it is the body that collects the revenue trying to get a thinner and thinner ability so that we can collect, so that the state can collect more revenue.
Further discussion on Amendment L002. Representative Sane.
Thank you, Mr. Chair. And I just want to remind folks again what this amendment does. So just a list of things that are made from oil and gas. From 142-gallon barrel of oil, you have ink, upholstery, bicycle tires, dresses, cassettes, motorcycle helmets, CD players, curtains, vitamin capsules, dashboards, putty, percolators, skis, tool racks, mops, umbrellas, roofing, denture adhesives, speakers, tennis rackets, nylon rope, water pipe, shampoo, guitar strings, antifreeze, clothes, combs, vaporizers, heart valves, enamel, anesthetics, dentures, cold cream, fan belts, refrigerators, diesel fuel. I can go on and on and on. That's what you've just done with this amendment. This just turned a bad bill and went full socialism.
Further discussion. Seeing none, the question before us is the passage of Amendment L002. All those in favor say aye. Opposed, no. Amendment L002 is adopted. Further discussion on House Bill 1468. Seeing none, the question before us is the passage of House Bill 1468. All those... Madam Assistant Minority Leader.
Thank you very much, Mr. Assistant Majority Leader. Members, I think what I heard over and over again was that we're just going back to the way the rules used to be. Well, the way the rules used to be was interpreted incorrectly by DOR, the Supreme Court came back unanimously and said, no, 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 that's not the way this is supposed to work. You need to refund that money. And so what we're going to do with this policy is tell any other industry that is going to come to Colorado that should you get a tax refund that's large enough that it impacts all the spending that we want to do down here, we're going to change the policy. We're going to make sure that you don't get that refund that you are actually entitled to under current tax laws. We're going to change it. And so you're right, this may not be the death knell for oil and gas in the state, but how many other industries are going to look at what we're doing right now and say, huh, Colorado likes to change the rules after we've taken the move to the state, submitted our tax forms, gotten our refunds, and the refunds ended up bigger than the state had bargained for. So then they're just going to change the policy. I don't think that's the kind of message that our state wants to put out. Are we going to be the kind of state that changes the rules halfway through the game, depending on how much money we want to spend down here? The Supreme Court ruled that DOR handled these cases incorrectly. They handled the tax refunds incorrectly. And that's the problem that we have. And the fact that we don't want to wait to have a good discussion, a good stakeholder meeting going forward, because next year we're going to be subject to Tabor refunds, just adds to the fact that this is the wrong policy at the wrong time, and we should not be doing this. This is sending the absolute wrong message to any other industry that's here or is thinking of coming to Colorado. I ask for a no vote on this bill.
Representative Wist.
Members, I'll be brief. We need to lead here. DOR made a mistake. DOR needs to own its mistake. And the last thing we do is force the taxpayer to pay for the mistake. That is what this bill is doing. It is pushing off DOR's mistake onto the taxpayer. So I appreciate the spirited discussion. I appreciate the sponsors' efforts to bring this issue to light. And in fact, it is a very important issue. But I think it also presents a very important opportunity for us as policymakers to say that when an agency of our government makes a mistake, they have to own it. Please vote no on 1468.
Further discussion, Representative Leonard.
Thank you, Mr. Chair. There was a question asked about we're going to lose $11 million, $5 million this year if we don't pass this, because now that this issue has been found out, and even though the state gets to keep the money that we have collected prior to this decision, now we're going to correct it, and we're going to lose maybe $5 million this year, and then $11 million, and then maybe $20 million. And there's no question with less revenue, the state gets to do less things. There's no question in that. But for us to collect money that we ought not collect, we should just limit. Now, we just signed the largest budget. The governor signed the largest budget the state has ever had. Granted, severance tax and the budget aren't coming out of the same pot, but our severance tax operational fund a couple years ago was $63 million of revenue collected. Went up to $78 million. That's a $15 million increase that we've had. It has nothing to do with tax policy. It had everything to do with the price and value of oil and gas, the amount of drilling that went on in our state, the demand and the supply that we had in. But either way, Colorado was able to reap the benefit of $15 million more. We added more programs and spent the money, obviously. And then the following year, last year, we had tough times because the industry wasn't there, and it was $30 million, from $78 million down to 30, a $50 million almost decrease, and that put us in a problem. No different than this $11 million would put us into a problem. But we were able to solve that problem. And I think to be able to say that we don't get $11 million next year, so we better change our tax policy because we really have the money already spent. There's folks out there with their hand out, ready to receive this money from all different counties. Ought we not pass this so that we can give this $11 million? Well, that same mentality would be no different than if we were going to decrease from 78 million down to 30 million. Shouldn't we raise our severance tax? So we really need to be able to focus on what's at hand. We get the revenues that we get in according to the industry, according to the market, and we spend them as we get them in. And we shouldn't have the end justifies the means here in this issue, and be able to follow the law that we have and the current costs, deductions that this industry has, because they're real and they're valid and they're the right place to base our collection of severance tax. So I would urge a no vote on this bill. Thank you.
Representative Winholtz.
Thank you, Mr. Speaker. I just want to touch a little bit on the Tabor impact. And on the fiscal note, the bill increases the state revenue from severance taxes, which will increase the amount required to be refunded under Tabor fiscal year 2017-18. Now, where have we heard that before? I urge a no vote on this.
Further discussion? Representative Sane.
Thank you, Mr. Chair. I'd like to move Amendment L004 and ask it to be properly displayed.
Amendment L004 has been moved and is displayed to the amendment. Representative Sane.
Thank you, Mr. Chair. We heard a story about the boy who cries wolf. Well, this is more like the man behind the curtain, and this is actually about priorities. Now, we heard earlier that we're so sad that certain projects like water projects and fire stations and other things couldn't be funded or may not be funded as much as we like, but we made that decision last year when we took money out of the severance fund. We made that a priority already. And we're making it a priority now not to put the blame where it belongs, which is DOR. That's where the blame belongs, not on the oil and gas companies. The blame belongs on the General Assembly for raiding those severance tax funds. So, members, I'm trying to make this very simple. This amendment actually simplifies the bill and does what I think we both wanted to do, which the oil and gas gross lease revenues less costs that may be deducted by a taxpayer as transportation, manufacturing, and processing costs borne by the taxpayer are deposited in the local government severance tax fund shall not be transferred to the general fund or any other cash fund. Let's make it a priority to close that loophole right now. Let's make it a priority to close the loophole of scraping through those severance tax funds that belong to our local governments and make that decision right now. I think that's a great decision to make in these last 72 hours. That's the decision we ought to be making. I urge a yes vote on this amendment.
Further discussion? Representative Becker.
Thank you, Madam Chair. As always, Representative Sane, it is a pleasure to serve with you.
And also with you.
And I appreciate, again, the creativity. I appreciate the effort to say the severance tax money won't be raided. I don't know that there's going to be that much left after the Supreme Court decision to really raid. But I do think it unduly restricts the ability of the General Assembly to do what it needs to do in the future, and we really can't dictate this in statute anyway, because you can't bind future legislators. So I ask for a no vote.
Representative Becker, Jay.
Thank you, Mr. Assistant Majority Leader. Members, I think this amendment's pretty responsible. I think it's doing exactly what we've asked and been asking all night. And if we're so worried about severance taxes, why does it not make sense that we keep them where they belong? If we're so worried about those projects that we didn't worry about as we were pulling these funds before, we didn't worry at all about those projects when we were rating these funds, but now all of a sudden those are important projects. This makes a lot of sense. This actually makes us responsible for those projects that we're supposedly fighting for here tonight. This makes it clear as to what we need to be doing. If we're so worried about the communities that we have rated these funds for, let's prove it right now, pass this amendment, and lock these funds into where they're supposed to go to. Those water projects for those communities, to DOLA, to give grants to communities. This amendment makes way too much sense for us not to vote yes on. I would hope that since we've been fighting and talking about these projects, that you now can take the time to vote for those projects and give clear direction to oil and gas to exactly what they need to be doing. If we don't pass this amendment, I'm not sure we're giving a clear message. I think we're telling them we're not sure we know what we want to be doing. I think we're telling them we're not real sure. We're going to argue that we want to protect those water projects and we want to protect the grants and communities. But if it really comes to it, we're not going to do it. Let's pass an amendment that lets us protect that. I hope that we can have your support on this amendment.
Further discussion. Mr. Minority Leader.
Thank you, Mr. Chair. And members, I find it kind of odd that now all of a sudden we're concerned about all of the things that severance taxes pay for. Oh, well, you know, we got to make sure that there's a lot of money in that account to pay for this project or this water project or all of that. Well, somehow we weren't concerned about that last year when we rated this fund, and how we've rated this fund time and time and time again. And we made all of the same arguments before, and somehow in all of those years past, we didn't care about severance tax dollars or care about how much that we left in that fund in years past. But all of a sudden this year, it's become this big thing that, whoa, no, whoa, we got to protect this fund. We have to protect all of these projects and all of the things that are out there. Members, this will go back and this will speak volumes to our severance tax. We need this amendment. I urge an aye vote on L004.
Representative Neville.
Thank you, Mr. Chair. Members, I also urge an aye vote on this amendment. You know, it strikes me as a bit curious that here we say we are losing money if we don't pass this bill, when in reality, we all know that the money was never ours in the first place. It never was. And the Supreme Court unanimously said it was never our money. Just like these severance tax dollars were never the state's money in the first place. We should have never rated those funds. They weren't for us. And I think that's what this amendment does. It says that we're going to keep that money local. I urge a yes vote.
Further discussion on Amendment L004. Seeing none, the question before us is the passage of Amendment L004. All those in favor say aye. Aye. Opposed, no. No. Amendment L004 is lost. To the bill. Further discussion. Representative Becker.
Thank you, Mr. Assistant Majority Leader. Members, we've been talking a long while on this, and I assume we're going to be speaking a little while longer. We're going to sit here after oil and gas has won a Supreme Court case, and we're going to punish them. We're going to punish the taxpayer for proving that the Department of Revenue was collecting taxes that they shouldn't have, and that they'd been warned several times that they were collecting taxes that weren't theirs. And then on top of that, when those taxes came in and we thought we had more, we stole those and put them into the general fund. We had the right to do that. But then we sit up here and say, wow, if we allow this Supreme Court case to go through, all of these projects will be affected. All of these communities will be affected. All of these water projects will be affected. But you know what? I didn't hear that when we were stealing those dollars. But now all of a sudden we were worried about them. This is way too late in the game to even be having this argument. This bill shouldn't have came forward. The state of Colorado lost because of what the Department of Revenue was warned against and kept doing. And now we think in the last few hours of session, we can come up with a logical solution to what's going on and punish the taxpayer that already won in court. That makes no sense. This bill doesn't make any sense as we're moving forward if we truly want to have a conversation. I don't think we can sit here and we can let the press and the people listening think that we are protecting these projects when we all along agreed to raid those funds. To the tune of 400 and some million, we raided those funds. And now we come back and say it's just not fair. Well, guess what? It is fair. The Supreme Court already ruled on it, and here we sit trying to overrule that. It's not fair that that's what we're doing. It's not fair that we're sitting here in the 11th hour trying to fix it. And it's not fair that we all of a sudden are worried about these projects when we were warned about these projects all along, and we're cutting them anyway because we had such a drop. I ask for a no vote on this bill.
Is there further discussion? Representative Everett.
Thank you, Mr. Chair. The Department of Revenue, this is just another fumble on their behalf. They've once again fumbled the ball. Even after the Broncos won Super Bowl 50, the Department of Revenue is fumbling the ball again, and now they're crying and say, hey, come bail us out. We messed up. Legislature. Now, I get this, but this is the problem with having a large government bureaucracy where you have bureaucrats that are in the same job year after year and year after year and don't see the big picture on what they really need to be doing and what they need to be focusing on and actually applying the law as it's supposed to be. This is exactly how we end up in these types of messes. Every time. Every time. And here we have to be here in the 11th hour. It's more like the 11th hour and 45 minutes trying to fix this, guys. Fellow legislators, not our responsibility. We're going to have to eat this. We're going to have to figure out where we can actually make cuts instead of sort of changing the rules in the middle of the game, at the end of the game, begin of the game. You know, part of the problem is that, you know, we saw through the primary process this year, for example, you know, there were certain candidates said, well, you know, the rules were there, but I didn't like the rules. I didn't participate, so I should still get a ribbon. Well, you know what? That's how this applies to the Department of Revenue as well. They didn't follow the rules, and now we're going to change the rules of the game late in the game. And that's just an equity argument. So we hear arguments about equity constantly in this building. All about equity. Equity, equity, equity. Well, you know what? We need to treat these oil and gas companies and all the way down the production line in an equitable fashion. And that's by not changing the rules of the game in the middle of the game. But let's talk about the business process that, you know, I'm reading this bill and at the 11th hour and 45 minutes. And why are we treating oil and gas differently? We're saying they can't write off the simple cost that any business would be able to write off as the cost of doing business. Simple accounting rules, and again, we're changing them in the middle of the game. And this is just so unfair. Absolutely so unfair. So for all of you that make those arguments about equity, well, step up and vote no on this bill.
Representative Carver.
Thank you, Mr. Assistant Majority Leader. I also rise in opposition to this bill. You know, when we are talking about a significant change in tax policy, it is astounding that we would follow a process that would have such an impact on the oil and gas sector, a critical sector in our economy, that provides not just direct, well-paid jobs for our state, but all of the subcontractors, the ripple effects, the billions of dollars this adds to our state economy. And yet, this bill, along with all the other bills that have put this sector under attack, what message does this send to the oil and gas sector that we follow this Supreme Court ruling, unanimously ruling in support of this industry, which was treated with the state agency improperly interpreting this aspect of tax policy. We rush a bill to the floor, not allowing the normal process for input, for full public discussion, to really look at the significance of this tax policy. Rush to the floor to do what exactly? Rush to the floor to, let's not waste another opportunity to send a message to oil and gas that we are going to take a more punitive and restrictive role to the deductions you're allowed to take for your infrastructure. Not exactly a pro-business message to be sending. And so I think this process is deeply flawed. I think the message that we are sending to the oil and gas sector is a very interesting one, when at the same time we hear argument after argument about the need to grow the economy, how important well-paid jobs are, how important growing a sector that has ripple effects, the multiplier effect throughout our economy, and yet we go after this sector time after time after time. And so I just think at every level, process, on the merits, substantive tax policy, fairness of treatment of this sector versus any other important industrial sector in our economy, that we need to vote this bill down. And so I would certainly urge a no vote. And really, there is no rush that we need to make during this session to address this issue. We need a thoughtful approach, and quite frankly, an approach that treats this sector with a little bit more respect. I urge a no vote.
Representative Quorum.
Thank you, Mr. Assistant Majority Leader. I'm so happy that we're all talking about severance tax and protecting water projects, communities, DOLA. I don't know where you all were Thursday when I ran this bill to protect all of that. I gave you all the opportunity Thursday to do exactly that. Protect severance tax, protect the communities. Perhaps we should have done it. But members, I'm a little concerned that we're in the 11th hour, pretty close. And we're talking about something that is so important. I don't think we can do this in the short time that we have. I think it's something that needs to be corrected. You know, I think Department of Revenue made some major errors. In my world, I operate on a very simple philosophy. When you mess up, you fess up, and you move forward. And I think that's what we have to do with Department of Revenue, to sit down with everybody at the table and say, what did we do wrong? How do we correct it? How do we protect those water rights, those construction jobs, the money that DOLA puts into our communities? Members, severance tax is down 70%. And frankly, it's not looking any better. I went to a seminar the other day, said we don't expect the oil and gas industry to be back to $60 crude before 2020. I'm gonna like it personally. I have a 600-mile trip every week to go home. And it's cost me half of what it did a couple of years ago. But members, we're worried about severance tax today. But what we really need to be worried about is the severance taxes of tomorrow. Because they also told me in this seminar that the rig count is way, way, way down. And their projections are that it won't be back to Colorado. They said what we're going to do when the price does come back, we're going to send those rigs to where it is the most economical for us to do business. Severance tax is only a minor part of that. Delays in regulations, redundancy, paralysis by analysis is what we're doing to this industry. I have friends that are in the oil and gas industry in the Dakotas and Montana. It's a 15 to 20-day project to get permitting done. You know, we were asked to put a situation on where we estimate where we're going to drill, when we're going to drill, and why we're going to drill for 5 years. Pretty hard to do that when the funds aren't there, the incentive is not there. You really need to think about that. I'm also thankful for the oil and gas industry in my community. My airport, Montrose Regional Airport, is the second busiest airport in Colorado. 10% of their flights, their passengers, are coming from Grand Junction. You think, well, Grand Junction is a larger community. But they're coming to Montrose because they can connect better to jobs in the Dakotas, in Montana. Members, the oil and gas industry is not stupid. They're absolutely not stupid. And they're going to go where it is the most economical, the most feasible for them to do business. They love Colorado, but Colorado doesn't seem to have the love for them. So I think that we need to vote this bill down. We need to take a deep breath. Perhaps it's something we should look at over the summer. I'm surprised that the bill did not come to either Ag and Natural Resources or Transportation and Energy, because those are the committees that normally hear these bills. So I would suggest that we take a deep breath, settle back, come up with a game plan we can work on over the summer and try to come up with a resolution. And I truly do want to protect those water projects, those communities. I ask for a no vote.
Okay. Members, I have been exceptionally lenient on the discussion this evening. If you are not discussing the substance of the bill, I will be reminding you to discuss the substance of the bill. Representative Sane.
Thank you, Mr. Chair. Or I'm going to try one more time here. I'm going to move L005 and ask that they be properly displayed.
Amendment L005 has been moved and is displayed to the amendment. Representative Sane.
Okay, so I'm trying to simplify this into something that we can reach an agreement on in this late hour. And so what my amendment does is, it says the Department of Revenue shall interpret the allowable deductions for any transportation, manufacturing, and processing costs borne by the taxpayer in a manner consistent with the Colorado Supreme Court's decision and BPAM versus Colorado Department of Revenue 2016 CO 23. Where the parties to the sale are related parties and the sales price is lower than the price for which that oil or gas could otherwise have been sold to a ready, willing, and able buyer, and where the taxpayer was legally able to sell the oil or gas to such a buyer, gross income shall be determined by reference to comparable arm's-length sales of like kind, quality, and quantity in the same field or area, less deductions for transportation, manufacturing, and processing done prior to the sale. For the purposes of this paragraph, related parties shall be defined by the Department of Revenue pursuant to rules and regulations. So what this will do is bring the bill in line, and I know we want to be in line with the Supreme Court. I know that we want to make sure that we are doing the right thing legally. So this amendment achieves that. I would urge a yes vote on this amendment.
Further discussion on Amendment L005. Madam Majority Leader.
Thank you, Mr. Assistant Majority Leader. Based upon the request of the sponsors, I move to lay over House Bill 1468 until tomorrow, May 10th.
You've heard the motion from the Majority Leader. Seeing no objection, the bill will be laid over at the request of the Majority Leader. Madam Majority Leader.
Thank you, Mr. Assistant Majority Leader. I move the committee rise and report.
You've heard the motion. Seeing no objection, the committee will rise and report.
The House will come back to order. Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over the balance of the special orders calendar until May 10th.
The motion is lay over the balance of the calendar until tomorrow, May 10th. Seeing no objection, so ordered. Mr. Kohler, please read the report of the Committee of the Whole.
Madam Speaker, Committee of the Whole begs lead reports on consideration of the following attached bills being second reading thereof makes the following recommendations thereon. Senate Bills 19 amended, 35 amended, 69 amended, 87 amended, 146 amended, 150, 161, 163, 169 amended, 180 amended, 196, 199 amended, 203, 204, 208, and SCR 2 passed on second reading in order revised placed on counter for during final passage. House Bill 1468 amended, laid over until May 10th, retaining is placed on the calendar.
Representative Primavera. There are amendments on the desk, and I hope I have a copy of them. Thank you. Mr. Kohler, please read the Representative Joshi amendment to the Committee of the Whole. Sorry about that, Representative Joshi.
Representative Joshi moved to amend the report of the Committee of the Whole diversity action taken by the committee not adopting the following Joshi Amendment L019 to Senate Bill 146 to show that said amendment passed and that Senate Bill 146 as amended passed.
Representative Joshi.
Thank you, Madam Speaker. I move the Joshi Amendment to the Senate Bill 16-146.
Proper motion and properly displayed. Please proceed, Representative Joshi.
Members, we had pretty good debate about this issue. We all want to do most of our laws in line with the federal statute and federal laws. But this particular issue, we did not do it properly, it seems like. We ask physicians or other medical providers to provide preventative care, and vaccines are part of that. But then we did not do what the federal statute says. And just to remind you one more time, let me read what it would do. This amendment will do if a healthcare provider administers a vaccine to a minor in process of providing care, preventative services, or treatment for sexually transmitted infections, the healthcare provider shall provide, prior to the administration of the vaccine, the minor's parent or legal guardian with appropriate risk and benefit information related to the vaccine in compliance with the federal statute. This is very, very important because the parents have to know what is going on with their children. All of us who have children, grandchildren, we all want to know what is going on with them when we take them to the doctor. Because it is important, the treatment may be good, but it can also have side effects. And when side effects occurs, the parents wants to know what is going on because they will be involved in that treatment, they are paying for it, and so on. So I ask for your yes vote on this amendment.
Representative Neville.
Thank you, Madam Speaker. Members, I think this is a good amendment. You know, this truly addresses parental rights. Say what you will about vaccines or not, but this addresses that the parents have a vested interest in this. They need to have informed consent before this is performed on their children. So regardless of how you feel about the actual vaccinations, I'm pro-vaccination. I'm just also pro-parental rights. And I think that parents should have a fully informed decision before this is performed on their children. So I urge a yes vote on the Joshi Amendment.
Representative Everett.
Thank you, Madam Speaker. So again, we're talking about the federal standard here. So are we going to have the federal standard in one area and then a different federal standard or not want to apply this? So here's something that deals directly with the bill, with the STIs, and here's a federal standard that involves parental notification. So why can't we have that standard in the other part of the bill? I think that this sort of emphasizes that the federal law, and when we look at federal law to lead us, instead of trying to put our Colorado stamp on it, this is where we run into a problem. Colorado needs to put parents and children first. We got to make sure that we have the best parent-child relationship, and the government should not get in between that. I urge a yes vote on this amendment.
Further discussion, Representative Humphrey.
Thank you, Madam Speaker, and members. I rise in support of the Joshi Amendment to the Committee of the Whole report, and again, this is just aligning things with federal law. That is a great idea, and parental rights are critical. And we don't want to be communicating that we think that parents are a barrier to children's health care. I urge a yes vote.
Representative Ransom.
Thank you, Madam Speaker. And just real quickly, we're talking about parents' rights. That's what we've heard the last couple people say. I also want to speak about parents' responsibilities. If there are side effects, if there are any problems with the vaccine itself, then the parents are responsible for making sure that the child or teenager gets the proper follow-up treatment. They're responsible for paying for it and for knowing what allergies might be in existence. And for that reason, I urge an aye vote on the amendment.
Further discussion? Seeing none, the question before us is the Representative Joshi amendment to the Committee of the Whole regarding Senate Bill 146. Mr. Kohler, please open the machine and members proceed to vote. Representatives Patterson and Rankin. And Becker. Close the machine. With 34 ayes, 34 noes, and no excused, the Joshi amendment to the Committee of the Whole is lost. Mr. Kohler, please read the Representative Singer amendment to the Committee of the Whole.
Representative Singer moved to amend the report of the Committee of the Whole diversity action taken by the committee not adopting the following Singer Amendment L052 to Senate Bill 169 to show that said amendment passed and Senate Bill 169 as amended passed.
Representative Singer.
Thank you, Madam Speaker. Once again, I encourage an aye vote on the Committee of the
Representative
Whole.
Singer, you need to move the
I move the Singer Amendment to the Committee of the Whole.
proper motion, and it is not displayed yet. Can we get the Representative Singer amendment displayed? That's okay. There we go. Properly moved and properly displayed. Please proceed, Representative Singer.
Thank you, Madam Speaker. Once again, this inserts due process into a system where we are taking people's freedom. This is arguably one of the hardest things I've had to do. I really, truly respect the two members that have brought this bill. But in order to make sure that we protect the rights of our individuals, we need to seriously consider, especially after that first 72 hours, whether the courts need to insert themselves and we need to present clear and convincing evidence that that person is presenting a harm to themselves, others, or whether or not they are gravely disabled. This is something that happens, people. This is something that happens today where people are held and held and held indefinitely. This prevents that or presents a safeguard. And so with that, I encourage, once again, encourage an aye vote to the Singer Amendment.
Representative Krafthardt.
Thank you, Madam Chair. With all respect to Representative Singer, I encourage you to vote no. Representatives, this amendment does more than just repeal. Due process. Goodness, this amendment does more than just due process. It does the 2-year repeal. It minimizes the role of the Department of Human Services, and the due process creates a court standard that is more appropriate for short-term treatment. This is not the right amendment. Thank you.
Representative Landgraf.
Thank you, Madam Speaker. This, I agree. This is not the right amendment. Vote no.
There further discussion? Seeing none, the Representative Singh.
Thank you, Madam Speaker. And members, I'm going to have to vote yes on this amendment. It puts me in a bad position because there is due process at stake here. But at the same time, it's going to cost some of our rural hospitals money. And so if this passes, I'm going to be determined to find that source of money for rural hospitals. But at the same time, I can't deny due process for folks that are being held. So I will be a yes vote on this amendment tonight and urge a yes vote.
Seeing no further discussion, the question before us is the Singer Amendment to the Committee of the Whole. Mr. Kohler, please open the machine and members proceed to vote. close the machine. With 14 ayes and 51 noes, the Singer amendment to the Committee of the Whole report is lost. Mr. Kohler, please read the Representative Klingenschmidt amendment to the Committee of the Whole.
Representative Klingenschmidt moved to amend the report of the Committee of the Whole diversity action taken by the committee not adopting the following Klingenschmidt amendment L018 to Senate Bill 69 to show the Senate amendment passed and the Senate Bill 69 as amended passed.
Representative Klingenschmidt.
Thank you, Madam Speaker. I move the Klingenschmidt amendment to the report of the Committee of the Whole.
Proper motion and properly displayed. Please proceed, Representative Klingenschmidt.
Thank you, Madam Speaker. So I bet you all thought I was going to cow the marriage amendment. But no, I'm here to talk about firefighters. And, you know, firefighters are an important part of our community, and the paramedics are an important part of our community. And we heard this bill in committee. And I want to applaud Representative Pabon for working through a stakeholder process with the paramedics and the firefighters from many communities, including 6 communities whose firefighters and paramedics opposed more government regulations. And yet, they were promised an opt-out. They were promised an exemption, that they could continue the excellent programs they have without more government regulations. And that promise was kept by the Senate version of the bill. When the Senate passed their version, there was an exemption for Longmont, for Colorado Springs, for 4 other communities. I don't know all their names, but some of you are representing those firefighters and paramedics who do not want more government regulations. And so the Senate version had the exemption. They don't have to adopt this new program that's going to come out. And now we come to the House. And the House, God bless Representative Pabon, he killed the Longmont exemption in committee. Now they're not exempt. Oh, they'll be exempt for 5 years, and then it's sunset. Then the exemption goes away. And then all of these stakeholders who came and opposed government regulation but were promised an out, promised an exemption, their exemption is gone. It's out the window. And now all of the firefighters, all of the paramedics are going to get more government. And I think it was a promise broken to the Senate. My amendment fixes that. The Klingenschmidt amendment will honor all of the stakeholders who were in the room through that process. All of the stakeholders, including the Colorado Springs and Longmont firefighters and paramedics. They will keep their exemption. It will not sunset on a date certain, and they will continue to go forward and do good things and take care of people in their homes without more burdensome government regulations on their excellent work. I urge a yes vote on the Klingenschmidt amendment, and this will make all of the stakeholders feel included instead of feeling like they were made a promise. That promise was kept by the Senate and broken by the House. We need to honor that promise here in the House, too. I urge a yes vote.
Representative Humphrey.
Thank you, Madam Speaker, and I'll be brief. I just didn't want to have Representative Klingenschmidt be the only person down here to testify in favor of this. I recommend a yes vote or an aye vote, as he would say, on this cow. Currently, these folks are not subject to regulation by any state agency, and they're actually able to make a living. That's pretty amazing. But they want to be regulated. But there's this one group that doesn't. So. And that was included in the bill originally. Let's honor that. I urge an aye vote.
Representative Pabon.
Thank you, Madam Speaker. I'll be brief. I oppose this amendment. Representative Klingenschmidt, we did have a robust hearing. That is correct. We may have been in 2 different hearings because I don't remember any opposition actually to the bill in the hearing. So correct me if I'm wrong, any members that were there, but there was no opposition. The issue here is simply just implementation of these guidelines. And just to be very clear what the bill does, it's an opt-in system. So no one is required to become a community paramedic or provide these services. If they want to, they can. So what we said with the exemption is those communities who are already doing this, you've got 5 years to adjust your practices. which is an enormous amount of time to conform to the current regulations, the current community safety standards, the consumer safety standards, and that's what this is about, is consumer safety, consumer standards. So I ask for a no vote on the Klingenschmidt amendment, and hope you'll support me on that.
Seeing no further discussion, the question before us is the Klingenschmidt amendment to the Committee of the Whole report. Mr. Kohler, please open the machine and members proceed to vote. Representative Conti and Representative Foote. Close the machine. With 29 ayes and 36 noes, the Klingenschmidt amendment to the Committee of the Whole is lost. We are now to the Committee of the Whole report. Mr. Kohler, please open the machine and members proceed to vote on adoption of the Committee of the Whole. Close the machine. With 65 ayes and no noes, the report of the Committee of the Whole is adopted.
Yes. But I don't have those intros.
Oh, do you have those intros?
Conference Committee reports.
The first report of the First Conference Committee on Senate Bill 106. This report amends the re-revised bill.
Message from the Senate.
Madam Speaker.
Message from the Senate will be printed in the Journal. Introduction of bills.
Senate Bill 183 by Senator Sheffield and Kerr, also Representatives Williams and Lawrence, concerning clarification of the General Assembly's intent to maintain the Public Utilities Commission authority over basic emergency services while prohibiting the regulation of Internet Protocol-enabled services by defining the term basic emergency service in a manner that is consistent with such intent.
Senate Bill 183 is assigned to Business Affairs and Labor.
Senate Bill 210 by Senator Baumgartner, also Representative Del Grosso, concerning infrastructure funding in connection with requiring the Transport Commission to submit a ballot question to the voters of the state of the November 2016, 2017, or 2018 election, which, if approved, would authorize the state with no increase in any taxes to issue additional transportation revenue anticipation notes for the purpose of addressing critical priority transportation needs in the state by financing transportation projects, and would include note proceeds and investment earnings on note proceeds from state fiscal year spending limits and dedicated 5% of state sales and use tax revenue for state transportation purposes and 1% of such revenue for other capital construction purposes.
Very good. Senate Bill 210 is assigned to State, Military, and Veterans Affairs.
Senate Bill 213 by Senator Sheffield and Yuleberry, also Representative Singer and Del Grosso, concerning developing practices for construction defect litigation in connection with making an appropriation.
Senate Bill 213 is assigned to State, Veterans, and Military Affairs. You want me to sign it? And Judiciary.
State Affairs and Judiciary.
Madam Majority Leader.
Thank you, Madam Speaker. I move that the House lay over the balance of the calendar until tomorrow, May 10th.
The motion is to lay over the balance of the calendar until tomorrow, May 10th. Seeing no objection, so ordered. Madam Majority Leader.
Thank you, Madam Speaker. I move that the House stand in adjournment until 12:01 a.m. on May 10th.
The motion is to stand in adjournment until 12:01 a.m. on May 10th. Seeing no objection, so ordered. We're in adjournment for a while.